The appeal has been dismissed.
Obliged.
Yeah, my lord.
To look at are you like believe yes.
My lord, this matter may be possible for a moment, my lord. Mr. Tara is on the way, my lord. Due to some traffic congestion, my lord, we could not reach.
Okay. For a while.
For a while, yes.
Yes.
Obliged.
And for the victim, Lordship. Paper book is, we have already received the paper books. IA was for suspension of sentence, but since the other party has
Who's
not-
the learned counsel for the appellant? Where is the learned PP? Okay. Yes, paper book is prepared. Will you like to go for hearing on the main appeal?
My lord, the conducting counsel in this case, Mr. Dilip Majumdar, is his own personal difficulties, so we want to next there.
No, we'll give you a date since the paper book has been prepared. We can fix this matter for hearing,
Yes, yes, my lord.
okay? Instead of giving time on the IA, we'll have this for hearing, brother.
Yes.
Yes.
The learned counsel for the parties, including the respondent number 2, are present. The paper we have present. We have also noted that the paper book is ready and copies thereof served upon the learned counsel for the respective parties. Sarah? Do a prayer for adjournment has been made on behalf of Sri D. Mazumdar, learned senior counsel, for the appellant. We are of the view that the matter, that the appeal itself can be listed, can be directed to be listed for hearing. Accordingly, let the appeal be listed for hearing. When?
30th of June.
On 30th, 30.
30.
On 30th of for hearing. As agreed upon. As requested, list this case for hearing, list this appeal for hearing on 30/6/2025.
Yes, be obliged.
Number 4.
Item number 4. Michina Nibo. Item number 4. IA for what, madam? Yes, additional people. This item 4 is what? IA in writ appeal. Yes, the government counsel, Mr. Ratan.
My lord.
IA for what?
My lord, this I am
Notice also has not been served by them. So
You should come prepared with the, where is your brief? You know, there's no government advocate.
I'll check my, we don't have the record.
Fair steps are required to be taken in this case. Where is the counsel for the applicant? None appears for the applicant on call, whereas we and Ratan learned AAG is present for the state, para, in the interest of justice. Matter is adjourned to be listed after a week.
May I please, Your Lordship? Your Lordship, this matter may be adjourned for today because conducting counsel T. Tafak is out of station. And matter may be least after 2 weeks.
On a request made by Sri T. Tapak, made on behalf of Sri T. Tapak, learned counsel for the appellant. The appeal is adjourned by 2 weeks. Sri so learned, you are the APP or PP?
PP.
Learned PP is present. Yes, 2 weeks.
Obliged.
Lordship, this matter has been transferred from Guwahati.
Paper book is there. Paper book is there, I think.
Lordship. Yeah.
Paper book is there.
Yes, Lordship.
Who's for the petitioner? Appellant,
Not turn up to the Lordship.
2000.
Is old case.
Okay, none appears for the appellant on call, whereas Mr. Learned PP is present. What's the para? In view of the above, and in the interest of justice, matter is adjourned by a week.
Deeply obliged.
My lord, I think he will take some time, my lord. There is a heavy traffic here, my lord.
And when?
Next week, my lord.
Okay.
Entry may be continued, my lord.
Lordship.
Is there any interim order?
Yes, status quo order is there.
On a request made on behalf of Sri T. T. Tara, learned counsel for the appellants, matter is adjourned by a week.
My lord.
Miss G. Ate, learned additional senior advocate is present. Para. Interim order to continue. Interim order of status quo to continue till the next date of listing. 5 minutes will sit. It is accordingly directed that an exercise be made by the ITBP to take a conscious decision regarding the nature of the position, and if the said land is required for a permanent purpose, immediate requisition be made to the district administration for initiating an acquisition process in accordance with law. In the event ITBP is of the opinion that such position may not be of permanent nature, then an exercise is required to be made by the district administration for ascertaining the rental value for the land in question for the period under which the ITBP is in possession, and thereafter the said rent be paid to the villagers community without any delay. It is also made clear that in the event the first option is opted to acquire the land, the requisition amount from the date on which the possession of the land was taken till the date when the land is acquired has to be paid in to the villagers community in accordance with law. It is needless to state that this court has not expressed any opinion on the amount of the quantum which is to be determined by the appropriate authority in accordance with the statute holding the field, namely so and so, and any person aggrieved would have the right to approach the authority under the said act against such determination. Aforesaid exercise of determining the nature of the requirement of position by the ITBP is to be done within a period of 1 month from today, and thereafter consequent steps be taken in accordance with law. Repetitions is accordingly allowed in the manner indicated above.
My lordship, this is one unlisted matter. Kindly, the matter may be listed on this 26th of May. Contempt case,
Fresh matter.
fresh matter. One is pending and one is fresh matter.
Fresh matter you filed when? When did you file the fresh matter?
No, this is already, matter is already in pending.
Pending, not
Yeah.
fresh matters.
Yes.
And why do you want? What is the
The
urgency?
urgency is, because, on 26, there is a other matter also is a fixed. And, a senior counsel is coming from Guwahati to appear.
No, 20, senior counsel will accommodate, but contempt, what is the urgency in a contempt?
Here, non-implementation of the High Court
What is the
order. is there.
urgency?
Urgency. Because,
There has to be an urgency if you are making a mention to be listed out of turn, there has to be an urgency.
on 26th, lordship, there is a matter is already fixed. Other matter also is fixed.
What are those matters?
One is, elementary and educational and that.
Now, how is this matter connected?
This is not connected, but,
Then-
matlab, this is not connected.
If it is not
But
connected,
kindly-
don't make a mention. Sorry. We normally are with the list of we always allow a mention. But not like this. There has to be some reason, some urgency. In a contempt matter, what is the urgency? First tell us.
The senior will be coming from
That is
Guwahati
not
on
a
that day.
reason.
only.
That is not a reason. We could have accommodated if there was an urgency. We normally accommodate all seniors, house session councils. Sorry.
May I please, my lord, I'd like to mention item number 8 and 9, my lord.
8 and 9, yes.
On behalf of S. Pandey, my lord, he is not well, so he cannot apply.
8 and 9, what is your prayer?
Yes, my lord.
What is your prayer?
My prayer, my lord, for adjournment, my lord.
Adjournment on
Yes.
behalf of whom?
S. Pandey, please.
IS Pandey.
Yes.
Yes, Parme, have you
Yes,
informed
I'm informing.
on a request made on behalf of the learned counsel for the petitioner? Matters are adjourned. Which is matters are adjourned by 1 week,
2 weeks, my lord.
by 2 weeks, 2 weeks. All matters, 1 week, 1 week, 21 matter. Why are you taking time 2 weeks? 1 week.
Yes.
1 week, Mr. Parme. Yes.
My please, Lordship. Lordship, this is a contempt regarding the non-passing of consequential orders by the respondent authority, Alice contemners. Lordship, in by order dated 4/12/2024, the Honorable High Court passed an order in writ petition number 299 of 2018, thereby quash and setting aside the land allotment order in respect of the private respondent number 6 and 7 in that writ petition. But thereafter also
Where is the order?
order lordship at phase number 24,
2-4.
24. And operative person is at lordship 37 phase number lordship, para 25. 37.
37.
Yes, lordship. Para 25. May I read the order, Lordship? In view of the above discussion, it's being an admitted position that the land so approved for allotment to the respondent number 6 and 7 by the communication dated 27/1/2018 and 10/12/18, respectively, as well as the allotment made in pursuance thereof in favor of the respondent 6 and 7 by the land allotment orders dated so and so respectively, having been demonstrated to have been so allotted out of 400 square meters of land initially approved for allotment to the petitioner society. The said land also falls within the
There is no
notified
appeal against this order.
lordship.
Is there any appeal against this order?
Yes,
Appeal is there.
yes.
Then,
Partly, lordship, the writ appeal has been filed in respect of the observation and order of this honorable single bench, whereby they declined to interfere with the cancellation in respect of the allotment made to the petitioners and affiliate. But here, Lordship, the land allotment in respect of private respondent number 6 and 7 has been quashed. That part has not been appealed. But even after quashing of that allotment or the respondent, at least contemners, the petitioner has furnished the certified copy to the authorities also. But as on that, they haven't passed any consequential orders. They were sitting over. And the
Third, Sri K. Lolin, learned counsel for the petitioner who has alleged willful and deliberate violation of the order dated 4/12/2024 passed by this court in WPC 229 of 2018. Full stop. The learned counsel has also drawn the attention of this court to the representation which was received on 4/2/25. Received. Represented 3/2/2025 duly received by the respondents. Full stop. Let notice be issued, no? Returnable by 4 weeks. Let step be taken for service of notice upon the respondents by registered post with AD. Steps within 2 days.
deeply obliged.
Item number 3.
Item number 3. Received.
Petitioner's counsel's name is not
Okay.
reflected.
Though this matter has been listed, comma, the name of the learned counsel for the petitioner. Yes, you're appealing. The name of the learned counsel for the petitioner has not been reflected in the cause list. Para, Ms. G. Atet, learned additional senior government advocate AP is however present. Para. Matter is to be listed on Thursday by reflecting the names of the learned counsel for the petitioners in the cause list.
This is second time today, coming up.
Okay.
Awesome. Last came up on 21 or 25, it was.
Today the names are not shown in the cause list.
Yes, yes.
Vocal number filed or not? Obviously it has to be filed. Why names are not shown? Person vocal number. Vibha Sharma. Vocal number has been filed by.
There also petitioner's counsel was absent.
Were the names of the council reflected in the cause list?
I can't remember, but on 21 for
Okay.
was two.
How about your name to the day after tomorrow? Thursday.
Item number 4.
क्या रहता है पहले कि माइक्रोफोन ऑफ हो गया Yes.
Four.
Four.
Matter relates to cancellation of GST registration, my lord. Matter
Mr.
relates to
You are
cancellation of
appearing.
GST, my lord. The lordship has also passed similar orders earlier occasion, my lord, revoking GST registration, my lord.
Page.
My lord, your lordships. Similar orders are, I have annexed, my lord, one of the order lordship will find at page 40, my lord,
40.
40. And
Who's appearing for GST? You would be appearing.
Lordship, for the government. Lordship, I have received an instruction. They are saying they are sending the comments, but then in instruction form they have.
This has come for the first time. This has come for the first time.
no, my lord,
This was no, Lordship.
But it's not
This
for
has come
motion,
for second time.
is it? What orders
Yes.
were passed? Notice was issued? No. Cannot be because it's come for motion.
This was issued on 13, 23/4/25.
no, my fixed for instructions, my lord.
No, it was fixed for instruction. He's correct. Notice was not issued. It has come up for motion. Okay.
I am paying that, my lord. Lordship, I have to revoke my cancellation, my lord. Upon payment of all taxes and dues, my lord.
He is annexed an order at page 40.
You know, there is other order page 58 also, my lord.
Heard 3 R.S. Mishra, learned counsel for the petitioner who has appeared online. Full stop. The challenge in this writ petition pertains to an order dated 21/10/2022 passed by the respondent number 3, whereby the registration of the petitioner under the Goods and Services Tax Act 2017 has been cancelled. Full stop. Para. When this matter was listed on the last occasion, that is 23/4/2025, instructions were directed to be obtained by the learned State Council. Para. In accordance with the same, Ms. G. Ate, learned additional senior advocate AP, has submitted that certain instructions have been furnished to her. Full stop. Let notice be issued returnable by 4 weeks. Full stop. Ms. Ate, the learned State Council, accepts notice on behalf of respondent numbers. All the respondents. Let extra copies of the writ petition be served upon her within 2 days. Para. Suri Mishra, the learned counsel, raised for an interim order and has submitted that this court in a similar case being WPC 6671 of 2024 has passed a judgment on 20/2/2025 in favor of the SSC in that case. Full stop. However, the impugned order in this case are of the year 2022, and therefore staying an order of 2022 in the year 2025 cannot arise. Full stop. The grounds taken by the petitioner would, however, be considered during subsequently after filing of returns by the state.
Lordship.
Can date be fixed, lordship permits, my lord?
Yes.
Supplies.
Can there be date fixed, my lord, lordship permits?
Yes, you tell us.
Any date lordship may fix.
List on when?
Lordship,
14 June, if lordship permits.
14th?
June.
14th June is Saturday.
Lordship,
Sorry,
that's
my
too
lord.
early.
We'll have it on 23rd June.
No,
23rd June.
Yes.
My
Okay.
business is stopped, my lord. I've not been able to operate business, my
No,
lord.
22 you're not operating,
Hello.
suddenly you cannot say.
Lordship, lordship,
That is why I asked, that was the final order, okay?
my lord. Oblige, your lordship.
Much
Clear,
obliged.
like.
Yes, item 5.
My lord, yesterday it was listed again. My lord wanted some judgment regarding the same. My lord, I could not find a similar circumstances to my case, but my judgments are all on alternative remedy, my lord. When
There is a direct judgment, we had hinted yesterday. When the presiding officer or a particular tribunal is found to be non-functioning for a long time, can your remedies be, can you be left with left with no remedy? You have not done adequate research.
my lord, this judgment, if
What is it?
my lord, this is PHR Even Education Society versus UCO Bank and
What is the ratio?
my lord, it says exceptional circumstances.
Those are Whirlpool phenomena, the three circumstances. We are not on
Four,
that.
my lord.
We are not on that. We are on the, if the adjudicating authority is not there for some purpose, then what do you do? Can you be left remediless?
Right.
Come again tomorrow.
My lord, in fact, there's another matter listed today only, item number 19, my lord, in the same line.
19, okay, 19 and this tomorrow. But tomorrow come up with judgment. We are not going to do research for it.
My lord, I'm not finding, my lord. Last night
We
I
have not done research properly. Nowadays, it's just a button. Not those days when you used to go after books. One button.
I know, my lord, but my exact circumstance, my lord, I couldn't find, my lord. I apologize.
We'll give you tomorrow.
Oblige,
On a request made by Sri H.K. Jammu, matter is adjourned. They will stay tomorrow.
oblige, my lord.
Your Honor, counsel is on the way. He's stuck in the traffic. Counsel is on the way, Your Honor. He's stuck in the traffic. Therefore, this
Are we other?
yes, Your Honor. Therefore, this matter may be kindly
We can,
passed over for time being, Your Honor.
time being.
Yes,
Okay,
sir.
we'll try.
Oblige.
The brief is with my younger. Yes, I kindly accommodate me for a week due to traffic jam, could not make it. For
Why?
tomorrow, Mila, for tomorrow.
Tomorrow.
Yes.
On a prayer made by Sri T. T. Tara, learned counsel for the petitioners. Matter is adjourned to be listed tomorrow.
I'm grateful.
Sri so learned state council is present. Yeah. Item number? Yes, Mr. Kato. Madam,
Lordship, may kindly pass over the matter for time being.
time being, all time being, what will happen today?
No,
What will
Lordship,
sit in the evening?
no, Lordship. Yes,
Why?
because of one way.
So the vote was supposed to be on the 7th of December. They could not do it, but because of the order of this court now, they have closed down the road for the next 2 months.
Hello. Yes. Mr. Degar.
May I please, Your Lordship, in this matter, I am the petitioner. I have received affidavit, counter affidavit. So I need to reply, my lord.
Who has filed counter affidavit?
Uh,
The picture you have filed?
Yes, my lord. For 1, 2, 4, and 5. My lord.
Okay. When did you file?
I filed on.
8/4.
Yes,
Okay.
my lord.
Mahad Sri U Deka, learned counsel for the petitioner, as well as Sri B Picha, learned counsel for the department.
Yes, my lord. Study council. Rural development.
RD department.
Yes.
RD. Hmm. Who submits that affidavit in opposition has been filed, para? Sri Deka, learned counsel, praised for and is granted 3 weeks time to file rejoinder
Yes,
affidavit.
In item 12, may I pray some more time may be given, my lord. Although we have filed our affidavit, I have to seek instruction, my lord.
Okay.
It's regarding.
None appears for the petitioner on call.
My lords, I appear for the petitioner. We have filed our rejoinder affidavit yesterday in KEC International item 12.
Okay. You filed rejoinder yesterday. Is it on record?
Yeah, please, my lords.
No, rejoinder, we have not received, my lord.
We'll
I
again
have not
serve it.
received.
Okay. Who is your local counsel? Ask him to serve a copy to the learned
Please,
AG.
my lords.
What
Please,
is
my
your
lords.
name? What is your name?
Vishal Srivastava.
Third, Sri V. Srivastava, learned counsel who has appeared online for the petitioner. Full stop. He has submitted that the rejoinder affidavit has been filed yesterday. Full stop. Para. Sri N. Ratan, learned AAG, has however informed that copy of the same said rejoinder has not been served. Para. Sri Srivastava, the learned counsel, undertakes to serve a copy to the learned AG during the course of the day. Full stop. Para. Sri Ratan, the learned AG, has paid for some time to obtain further instructions. Para. List after a week. You want a date, Mr. Srivastava?
My lords, the date may be given.
You
My
suggest a
lords,
date?
before my lords, next Tuesday, 27.
Is it okay?
Okay.
On request, list on, you have some more time, list on 29th. 29th.
My lords, the arguing counsel is not available on 29th. The vacations start here in on 29th, my lords.
On 27th. On 27th.
Please, my lords.
All right.
All right, my lords.
Even though, my lord, the concerned junior assisting me in the case could not reach, but I have my file. I'm sorry about the list of books because all other things are with him. It has been a You have also. My lord, the pleadings are complete. The case is for hearing. Vedanta? Lordship may kindly.
You would like to argue for final disposal,
Yes, my lord.
Mr. Duff?
This is a matter of contract, my lord.
Yes.
Lordship may straight away turn to page 182 of the writ petition.
182.
Yes, my lord. This is the memorandum of the government of Arunachal Pradesh issued by Department of Power, laying down the guidelines to be followed in the Department of Power in the matter of tender and bid process, its evaluation and the award of contract. So this is the most significant thing. From here we begin. That is 18/9/23, the memorandum of the government of AP, page 182.
Yes.
Now, my lord, by this memorandum, they laid down the very concept of justified bid price ranges in terms of the categories. I'll begin with the recital, the very first paragraph of 182. Upon submission of reports and recommendations by the high-level technical committee constituted by number such and such, dated 28th August 2023, and within the terms of reference as mandated by EV number such and such, following guidelines with the terms and conditions are hereby laid out for adoption in the Department of Power with immediate effect for exercising in the course of tender or bid process, bid evaluation, and award of the contract works of projects and schemes. So by this memorandum, my lord, they brought in the very concept of justified bid price ranges in terms of the categories. Now, my lord, column 4 of the memorandum provides, I read that, para 4, to weed out under
Where is the aspect of justified bid?
My lord, I'll place it. Is this the part of the memorandum itself? Now, page 182 itself, the para 4, justified bid price ranges category wise, to weed out unrealistically very low and excessively high and obstructive biddings, the justified ranges of bid prices of materials and works as determined for respective category wise areas shall have to be adopted and adhered to in the bid evaluation process of tenders and the contract award therefore for execution in the Department of Power as contained in the following respective annexures. Now, category 1, my lord, will see Roman 5, Pasighat electrical division is mentioned here. And then, my lord, will also see para 5 at page 183. The validity of justified bid price ranges, para 5. The justified bid price ranges provided herein as above shall be valid for the bids of the tenders floated and processed for award during the current financial year 2023-24. From page 184 onwards, my lord, item wise, all details have been given. The ranges. Now, my lord, during the current financial year itself, that is the period during which the memorandum was operative, the NIT was issued on 17th January 24. 17 January 24. The relevant page, my lord, is page 41 of the writ petition. Here, my lord, we are concerned with the Pasighat specifically. NIT, page 41, Superintending Engineer Electrical Arunachal Pradesh, Department of Power, Pasighat, invites sealed tender for implementation of development of distribution infrastructure in East Siang district of Arunachal Pradesh under the revamped reforms-based and result-linked distribution sector scheme on turnkey basis from reputed firm such and such. The third paragraph, scope of work. Now, my lord, at the bottom, my lord, will find page 41, constitution of bidder and tenderer. C, 1C, pre-bid meeting will be held on 25th January 2024. Now, the pre-bid meeting was held on 25th January 24. And in the pre-bid meeting, my lord, before I come to the pre-bid meeting itself, my lord, there are 2-3 clauses I will mention of the NIT. The first will be clause 36 at page 91 of the NIT. Page 91. Clause 36 at page 91.
Yes.
Abnormally low bids. An abnormally low bid is one where the bid price in combination with other elements of the bid appears so low that it raises material concerns with the employer as to the capability of the bidder to perform the contract for the offered bid price. Then 36.2, in the event of identification.
What is the, just an interruption, what is the status now of the
The
work?
status is, my lord, there is this, yes. LOI was issued in favor of the respondent 9, and that was stated by the Honorable Court.
Stay order is operating. Okay.
Justice Surana passed the order, very elaborate order. I may read the order first, my lord.
No, at the stage of, before the work even started.
Yes,
Okay.
before that. Only LOI was issued, letter of intent. 36.2. In the event of identification of a potentially abnormally low bid, the employer, unless otherwise specified in BDS, may seek written clarification from the bidder, including a detailed price analysis of its bid price in relation to the subject matter of the contract, the scope, delivery schedule, allocation of risk and responsibilities, and any other requirements of the bidding document. And 36.3, after evaluation of the price analysis, in the event that the employer determines that the bidder has failed to demonstrate its capability to perform the contract for the offered bid price, the employer shall reject the bid. My lord, the purpose of showing clause 36 is to demonstrate that what was envisaged by the memorandum of 18/9/23 is embedded in the NIT itself. Because it conceives of a situation, one may be L1, but that by itself, would not culminate in awarding of contract to the L1. If it is abnormally low, not within the justified range, he will be out. Likewise, my lord, column 38, most advantageous bid. 38 at page 92. Having compared the evaluated.
What is this BDS means? At
For
36.2?
BDS, possibly the expression they are using, my lord, is standard bidding document.
Bid data sheet.
Bid data sheet.
Bid
BDS,
data sheet.
bid data sheet. So I, page 95.
All of details.
Details are given, my lord, in bid data sheet.
93.
95. Bid data sheet BDS.
Okay.
So, my lord, I am referring to clause 38. Most advantageous bid. Having compared the evaluated cost price of bids as per ITB 34 and applying the provisions of ITB 35, the employer shall determine the most advantageous bid, alternatively referred to as L1 bid. The most advantageous bid is the bid of the bidder who meets the specified requirement as per section 2 and section 3 and whose bid has been determined to have the lowest evaluated price cost subject to ITB 35. And clause 34 below deals with the evaluation of bid. That is at page 91, clause 34, the employer shall compare the evaluated price cost of all substantially responsive bids to determine the bid that has the lowest evaluated cost and price. So, my lord, this is the basic theme of the NIT. Now, pursuant to the NIT, immediately after NIT on 25th of January 24, there was a pre-bid meeting. The relevant portion of the pre-bid meeting, my lord, will find at page 1.
25th.
Yes, my lord, 25th of January 24. In my list of date also I have given that.
Yes, 187.
Yes, my lord. Page 187 is the relevant page.
Yes.
Here, my lord will find in the chart, column 5 at page 187. The query is whether justified bid price ranges of electrical distribution system in Arunachal Pradesh for various categories as notified by the government of Arunachal Pradesh White Memo number such and such dated 18th September 23 should be adhered to while quoting rates in price bid. The answer is yes. It will be taken into consideration while evaluation of the price bids in consonant with ITB clause 36 of the SBD. So the answer is affirmative, yes. The pre-bid meeting, my lord,
18/9/2023.
yes, my lord, that is it. So, my lord, pre-bid meeting was attended by all the bidders and it was clarified that that will be adhered to, the justified ranges. So, my lord, total 7 bidders participated. They submitted their tender. Out of that, my lord, 3 could qualify in the techno-commercial bid. 3 qualified. The first one is the petitioner, Mrs. DG Construction. The second is Messrs. Wind Power Infra Private Limited, respondent 9, represented by my esteemed colleague. Mrs. Wind Power Infra, R9. And the third is Mrs. Techno Power Enterprises. Techno is not before the Honorable Court. As to why it is not before the Honorable Court, not made a party, I will explain. So these 3, my lord, they qualified.
In the technical
Yes,
evaluation.
techno-commercial. Then, my lord, the price bids of all the 3 bidders were opened on 21st of February. On 21st of February. Here, my lord, will find the relevant portion, page 189. Page 189. Initially, my lord will find the names of all the 7 bidders were given. Page 189.
Yes.
Names of all the 7 bidders are there. Out of that, however, thereafter I read. However, out of the above bidders, the following bidders could qualify as 1, Mrs. Techno Power Limited, Kolkata, Mrs. DG Construction, Naharlagun. The rate analysis of the price bids of the above.
Wind Power is R9.
Yes, my lord. Wind Power Infra is R9 and DG Construction is the petitioner. The rate analysis of the price bids of the above 3 qualified bidders in techno-commercial bids have been thoroughly done as per government memo number such and such dated 18/9/23. The details of which are in the order of the following, such and such. Now here, my lord will find straight away. I'll take my lord to the findings. 204, page number. 204. That's the chart, the last page.
Yes.
Last page at the very bottom, above the signatures of all the members of tender evaluation committee. I read, my lord, the rate analysis of the price bids of the above 3 qualified bidders in techno-commercial bids have been thoroughly done as per government memo such and such dated 18/9/23. The detailed analysis is attached herewith is the annexure 1, details of which are in the order of the following. 1. Messrs. Wind Power Infra Private Limited has quoted minus 16% below the estimated cost put to tender, which is minus 10.25% below the minimum justified rate and minus 18.61% below the maximum justified rate. Hence, the price bid is rejected, being too low and not within the approved justified bid price range. That is in respect of R9, rejected. Then, my lord, Techno Power. Techno Power, which is not before the Honorable Court, was L1. It was declared L1. Mrs. Techno Power Enterprise Private Limited has quoted minus 6.17% below the estimated cost put to tender, which is 0.25% above the minimum justified rate and minus 9.08% below the maximum justified rate. Messrs. DG Construction Naharlagun has quoted such and such below the estimated cost put to tender, which is such and such above the minimum justified rate below the such and such rates. So the finding at last, in view of above, the price bid of Messrs. Techno Power Enterprise Limited Kolkata is found to be lowest as per the minimum and maximum justified rate and declared as L1 bidder as per government memo dated 18/9/23. Therefore, the price bid of Mrs. Tech Power Enterprises Private Limited is recommended by the E-Tender Opening Board for acceptance and approval, please. So, my lord, in my case, I was not rejected. It was within the justified range, but the Techno Power was found to be more feasible by the authorities. Thereafter, my lord, on 26th of February 2024, the Office of the Superintending Engineer submitted the comparative statement of price bid of all the three bidders to the Chief Engineer Power. That is Annexure 5. Lordship has seen that already. Now, the next is 12th March 24, because as per the requirement of the NIT and the SBD, the Superintending Engineer Electrical on 12th March 24 wrote to Respondent 9, informing it about rejection of its bid on the ground of being abnormally low. They were informed about it. That is Annexure 6, page 205 of the writ petition. This not relevant, my lord, I will skip it just to indicate that they were intimated about the rejection of their bid. Then comes, my lord, 14th of March 24. 14th of March 24. It's in the list of dates. Letter of the Superintending Engineer to Respondent 9, asking it to justify its abnormally low bid. So an opportunity was also given. You explain. How would you justify it? The Respondent 9, by letter dated 15th March 24, gave its justification. The letter, my lord, is not annexed here. It's not the part of the writ petition. The date we got through other records. 15th of March, he gave a reply. Thereafter, my lord, the reply was considered.
Yes.
15th March 24, he gives a reply. The reply considered, and on 22nd March 24, the Superintending Engineer writes a letter to Respondent 9 about consideration of the reply with the reasons. It is Annexure 10, page 211. This I will read. Page 211, my lord, Annexure 10.
Yes.
With reference to above, here the reference is given of the letter of 15th of March 24.
Yes.
With reference to above, the E-Tender Opening Board has once again minutely gone through the justifications given you for quoting abnormally low price in your price bid for package number such and such for the work development of distribution infrastructure in East Siang district of Arunachal Pradesh under the revamped reforms-based result-linked distribution sector scheme. Your justifications given by your letter at serial number 3 above for quoting abnormally low price bid has not been found satisfactory by E-Tender Opening Board. You have quoted 54 crore 98 lakh 73,157.44 against 65 crore 46 lakh 10,958.44 put to tender, which is minus 16% below the estimated cost put to tender and minus 10.25% below the minimum justified rate as per memo number such and such dated 18/9/23 of the government of Arunachal Pradesh, which is abnormally low. You may also refer our pre-bid meeting minutes issued white such and such dated 25th January 24, wherein it has been clearly mentioned at serial number 5 that the justified bid price ranges approved by the high-level technical committee as circulated wide above mentioned memorandum will be taken into consideration at the time price bid evaluation of bidders such and such. On the basis of above grounds, your price bid has been rejected by the E-Tender Opening Board. So, my lord, the rejection, 22nd of March 24 is the letter communicating the reasons. Then, my lord, by letter dated 26th of April 24, the superintending engineer also informed the chief engineer, Central Electrical Zone, about all the aforementioned developments. which culminated in the rejection of the price bid of respondent 9. This I will skip, not very relevant. Then 29th May 24. So all these things are happening, my lord. Then now the turn comes. The twist in the tail comes. On 29th May, they do nothing about it. So far as Techno Power is concerned, no LOI was issued to Techno Power. Nothing was done. Instead, on 29th May 24, the memorandum was issued from the Power Secretariat Government of AP, constituting a subcommittee under the chairmanship of the Chief Engineer, Central Electrical Zone. Now, my lord, this is all behind our back. Nothing is known to anybody. It is much later when the things were advanced and we came, my lord, this was known to us much later. At that point of time, everyone was absolutely in dark. The committee was constituted and the task of the committee was the re-examination of justification provided by the bidders. And my lord, the whole idea was they will carry out their own market survey on certain bases and parameters, and then they will rediscover and reanalyze all the rates. Meaning thereby, my lord, practically the 18/9/23 memorandum of the government of Arunachal Pradesh was given a go-by by constituting this very subcommittee. Now, the report of the subcommittee, my lord, will find it is dated 17th of January 24, and this is impugned also. The relevant portions of the report I will show to your lordship. I will start with page 238. There is okay, sorry. I mean, I stand corrected. It was 15th of July 2024. 345. In affidavit in bids received for the 6 packages, Rupa, Itanagar, Naharlagun, Namsai, Devmali, and Pasighat. This report details the methodology, findings, and recommendation based on a comprehensive analysis of the justifications provided by the bidders. Then, my lord, background for 5-6 lines are there. I will read that. A memorandum was issued via computer number such and such dated 29th May 24 from the Power Secretariat Government of Arunachal Pradesh, constituting a subcommittee for re-examination of justifications provided by bidders regarding low prices in the e-tender concerning the evaluation and awarding of contract for the RDSS package. Then re-examination process. The last lines. The committee shall examine whether the prices quoted in the bids identified as abnormally low require a justification from the relevant bidders. This review shall include an analysis of the bid with respect to the subject matter, scope, delivery schedule, allocation of risk and responsibilities, and any other relevant parameters outlined in clause 36.2 and 36.3 of the standard bidding document of RDSS. The provisions contained in the manual for procurement of goods and other instructions issued by the Department of Expenditure, Ministry of Finance, Government of India from time to time on the subject shall also be adhered to. Then speaking order. Following the re-examination, the committee shall pass speaking orders on the acceptance or rejection of the bids in question within a time frame of 15 days These orders shall be based on a clear and comprehensive assessment of each bidder's capability to perform the contract at the offered price and not merely based on any normative percentage below the estimated price for considering a bid as abnormally low. Now, my lord, I will show some more relevant portion, but my lord, I'm just in passing, I'm making one thing very clear. The most interesting part of this case is the report of this subcommittee was followed selectively only in our case. That is Pasighat package to favor respondent 9. It was not followed in respect of other packages. So far as other packages are concerned, in those packages on the basis of 18.923 memorandum, justified ranges, they acted as per that. It was a selective application. Now, my lord, few more things I will show regarding the report. At page 241, my lord will find action plan and timeline for submission of findings to the government. One Mr. Sabde Yomcha, assistant engineer, he was deputed to carry out the exercise. Then my lord will find page 244, market rates. Page 243 also, Lord, there's one thing I'll show. It's all right. Yes, 243. Page 243, Ballard will find conclusion, the meeting adjourned at 12:30 hours. My lord, just before the heading methodology, on top of the methodology, page 243, on 13th June 2024, whether my lord has got it.
Just a minute, please.
Page 243.
Just a minute, please.
It reads on 13th June 2024.
Yes,
Lordship will take note of the date.
yes.
13th June 2024, one more package, Pasighat, was ordered for re-examination. So initially, we know Pasighat package was not there.
That was what we are just trying to, we took the time, a minute's time. From 239 onwards, if you find the minutes of the meeting, at 238, only Rupa, Itanagar, Naharlagun, Namsai, Diomali and Pasighat were initially.
Yes, my lord.
But if you come to page 240, serial number 4, minutes. Rupa, Itanagar, Naharlagun, Namsai and Diomali. Pasighat was
Yes.
missing here.
Yes, Pasighat was not there. Pasighat,
And,
that is why.
even thereafter.
Yes.
Even-
Interestingly, my lord, Pasighat was
Even
inserted.
thereafter at 242 minutes, the first one.
Again, Pasighat is not there.
Pasighat is not there.
Yes. Pasighat was inserted. Pasighat was inserted on 13th June 2024. That is why. As an afterthought, my lord, they brought in Pasighat. That is why 13th June 2024. One more package. Pasighat was ordered for re-examination of justification provided by bidders regarding low prices such and such. In addition to the previously allocated 5 packages. Now, my lord, so far as previous 5 packages are concerned, I will demonstrate to my lord. In the 3 packages, they have followed 18.923 memorandum. Very selective. So that is how we came in. Now, my lord will find page 244, market rates. Page 244. As most of the vendors on the approved vendor list of REC, the REC, my lord, stands for, this is formerly a Rural Electrification Corporation. It is a Maharatna Indian Public Sector Company, REC. As most of the vendors on the approved vendor list of REC Limited for the DDU GGY scheme are based in Kolkata, which is the nearest manufacturing hub for electrical goods. Sri Sabde Yomcha, assistant engineer at the Kamba Electrical Subdivision, was deputed to Kolkata to collect first-hand information on ex-works prices of materials identified as decided by committee during the second meeting. The criteria for collecting ex-works price material were based on such as such and such. So, my lord, he had gone to Calcutta to collect the rates from the vendors of REC, Rural Electrification Corporation, a Maharatna company of the Government of India. Then the last three lines of page 244, the committee collected and considered ex-works prices of the identified items as per the approved vendor list of REC Limited for such and such scheme as noted in minute point number 3 of the second meeting such and such. Then market survey, page 245, the 5-6 lines, the first. Sri Sabde Yomcha, state engineer E of the Kamba Electrical Subdivision, conducted a market survey in Kolkata. So he conducts a market survey in Kolkata. He gathered the lowest ex-works price quotation for the identified items from the vendors and obtained quotations from several transport vendors for the transportation cost of these items from ex-works to the on-road freight destination. Copies of the ex-works rates and transport vendors quotation from Kolkata are annexed such and such. So this is how the whole exercise was carried out. And then after doing all this at page 247, Roman 6.
Pasighar.
Yes, Pasighar, Roman 6. The rates discovered through the market survey amount to rupees 47.202 crore, while the price quoted by the lowest bidder, that is Bin Infra, they are referring to respondent 9, is rupees 54.99 crore, which is 16.96% above the market survey rates. So that is how, my lord, they pushed the case of the respondent 9 after the rejection. Thereafter, my lord, all these things were happening, my lord, behind our back. Nobody knew anything. All these things were done surreptitiously. Now, on 15th January 2025, so, my lord, practically, my lord will find that is when the bid of when respondent 9 was rejected. When respondent 9 was rejected on 14th of March 24, from then onwards to 15th January 25, practically, Lordship may say around 7 months, there was a complete lull as to what was happening, how things were happening. Nobody knew anything. So 22nd March to 15th January 25, practically 8 months, 8 to 9 months. Then, my lord, on 15th January 25, the superintending engineer electrical wrote a letter to respondent 9.
But Mr. Tiwari,
My lord,
you have not read the conclusion and recommendation at page 250.
yes, I'm coming to that. There was a reason why I didn't read. I thought later on I will show.
No, this is not connected to Pasighar. So where is the recommendation of the subcommittee?
That is why, my lord, I thought I'll take my lord to
No,
that.
we have just had a look at, this is to
Yes.
relation to it another work where there are 4 numbers of bidders who were found to be capable.
My lord,
One,
the catch,
250.
my lord, the catch lies at page 249 in the chart,
Yes,
which
we have-
is not very legible
Yes, we
here.
have seen the chart. We try to see from the chart. It's not very legible.
No, it's not legible. No, my lord, in fact, in our affidavit in reply, the same page 249 we have reproduced, the better copy.
Okay.
So from there, I will show lordship certain relevant
But
things.
there has to be a recommendation, like in the conclusion and recommendation at 250. The recommendation is only pertaining to the NAMSAI package.
Yes. In conclusion and recommendation, nothing is specifically mentioned so far as Pasighar
Pasighar
is
is
concerned.
concerned.
There is total silence. My lord is right. That is correct. The catch lies only in the chart at page 249.
It's in the chart.
And that I will show, my lord, in our affidavit in reply. The same we have reproduced.
Page?
Page, my lord, in the affidavit in reply, it is, I'll show. Affidavit in reply against the affidavit in opposition of the government respondents. This is, my lord,
You just give me.
page 407, sorry. No, it's incorrect. I'll just,
It is
So-
358.
358.
358.
Just,
438.
438, sorry, just a
Hmm.
minute, that's mine.
Reply. By the yes.
No, it's, my pagination is different. That's the, actually pagination, no, is. Part one. Yes, my lord will find at page 438 of the affidavit in reply. I hope pagination is perfect. Page 438. Now, my lord will see the first chart, Rupa package.
Where?
Page 438 of the affidavit in reply. Against the affidavit in opposition of the state respondents. Respondent 126,
438.
438.
May not be correct. May not be correct.
No, I think pagination,
The last page is of the readings is 402.
just a minute, Lordship, sir, may I have a look at my lord's affidavit in reply? If something has gone wrong with the pagination. No, here it is in my copy.
Oh, yes, you're correct. What did you? This should come at the last. Okay, we have got it. You're correct. 438.
438.
Same
438.
your affidavit and our reply was fine. So there was some.
এখন উপর রাখিস, এখন তলত রাখি বলে। 438 or পিছত হয়ে গেছে। এখন লাস্টত রাখি বলে। এখন লাস্ট রাখি। এখন এটা 361 এর পিছত মানে লাস্টত রাখি। ওখানে রাখি বলে। এখন no problem. Yes, you have got it.
Now, my lord, the importance of page 438 and the three charts which are here, which we have reproduced from the subcommittee's report, annexed with the writ petition, the importance lies in the fact that the very purpose of subcommittee initially was in respect of the 5 packages, of which below Rupa, Itanagar and Naharlagun are the part of those 5 packages. Now, the subcommittee's recommendation in respect of those packages were not followed. On the contrary, my lord, I will demonstrate whatever my lord will find.
Where is the fair copy so far as Pasighat is concerned in your affidavit?
Pasighat,
You have only given 3.
in the affidavit of the government, page 356, the same thing. No, Pasighat, my lord, Pasighat is mentioned, page 357, in the affidavit of the government.
357.
357.
Yes, Pasighat is there. Yes. Yes.
Oh, I'll just. Yes, now, my lord, I'll just show one. To begin with, I'll start from page, that is 438 serially, otherwise 356. The Rupa package first. In Rupa package, my lord, just to show the comparison, how they have done things.
Yes.
In Rupa package, my lord will find the names of the companies and firms have been mentioned. At column 2, my lord will find Messrs. Jayant Count. Now, initially, my lord, Jayant Count was L1, the lowest bid. And in the justified range, applying the standard of 18923 memorandum, it was Messrs. T&T Project. So, my lord, if we go by the subcommittee's recommendation, Jayant Count ought to have been issued with the LOI.
Where do you make this?
Page 438.
430, yes, the 356, same. We have got
Yes.
the Rupa package.
Yeah. So Jayant Count was L1, my lord. actually.
From where do you get?
In subcommittee's report, my lord.
Okay, 25.7 was that
Yes.
one, okay.
L1.
Yeah, okay.
So going by subcommittee's recommendation, Jayant count ought to have been given the LOI.
Hmm.
LOI was not issued to Jayant count. It was issued to Messrs. TNT project, who was within the justified ranges by applying the standard of 18923 memorandum. L3, he was L3, TNT project. TNT project was issued with the LOI, and now I was told even the letter of acceptance.
Just a minute, just a minute.
We have annexed the letter of intent issued to Messrs. TNT project in our reply.
That means here the subcommittee's report was not adhered to.
No.
They
That
still
is why
stuck-
Jagdish Mandal comes in.
they still stuck with L3,
Yes.
who was TNT.
18923 memorandum.
L1 was given to L3, okay.
That is why not Jagdish Mandal I will bring in. Ulterior motive. Selective. Itanagar package, same thing, my lord. In Itanagar package, Lord will find the L1 was Messrs. SRB Techno. Itanagar package.
47.
Messrs. SRB Techno was L1
Yes,
as per subcommittee's thing.
yes.
L2 happened to be Messrs. TNT project. TNT project was again issued LOI and now letter of acceptance. Same thing, Nahar Lagoon package.
Who was L1 here?
In Nahar Lagoon package, L1 was Messrs. SRB Techno. But LOI was given to TNT project in terms of justified bid ranges of 18923 application L2. But in Pasighat, that's okay, it's all right. In Pasighat, Messrs. Wind Power Milot, lowest bid. DG Construction thereafter. Techno Powers, all along Milot, it was practically out of the ring, it never bothered. So,
Just a minute, please. Pasighat.
Pasighat. At page 357, in the affidavit
Yes, we have
in
got-
opposition of the government.
yes, yes. Pasighat, what has happened in Pasighat?
Pasighat Milot, Messrs. Wind Power, whose bid was rejected on the ground of being abnormally low, was held perfectly in order as per the subcommittee's report. Lordship has seen that recommendation. And
What is the amount? 54.
54 crores.
L what? L? R what? R,
L1 was
No, no.
initially Messrs. Techno Power,
Queen is R what? R9.
R9. Messrs. Wind Power was R9, whose bid was abnormally low and rejected. This was held perfectly in
So
order.
R9 was found L1 by the subcommittee and give LOI also given.
Yes. And Messrs. DG Construction was out of the picture.
And what about Namsai and Diomali?
Milord, we don't have the details of
Okay,
Namsai and Deoman.
Okay.
Okay, my lord, instruction is, so these are oral instructions, nothing, no material on that. It is given as per 18.9.
But so far as Rupa, Itanagar and Nahalaguna are
Yes,
concerned,
confirm.
that
We
is
have the
your
materials.
case, that in spite of the subcommittee declaring a
Yes.
particular bidder as L1, this still stuck to the
18.9.
18.9 and had given to the justified bid.
Yes. Then, my lord, I'll now come to the again sequence of events. So 15th of January 25. In the meantime, the subcommittee is there functioning and all that. On 15th January 25, the superintending engineer wrote a letter to respondent 9 informing it of the acceptance of it bid by the state government on the strength of the report of the subcommittee. This is impugned. 15/1/25.
Just a minute, please. 15? One yesterday.
15/1/25.
What is this, 15-1?
LOI, my lord.
Okay.
Page 16, page 2021, 220, 221. Just a minute.
220.
Page 220. This has reference above. This has the reference above. It is notified that in pursuance of Chief Engineer Power, Central Electrical Zone Itanagar approval referred to such and such or offer for the work such and such against the NIT number such and such has been accepted on behalf of the Governor of Arunachal Pradesh at the quoted rate amounting to rupees such and such. You are requested to submit unconditional and irrevocable bank guarantee in favor of the executive engineer passing out such and such. Total contract price. This is it. So, my lord, LOI was enclosed along with this communication. Now, my lord, there were few dates, my lord, since I just because from
Yes.
my lord 15th of March 24 to straight away I went to the committee. During this period, my lord, period of interregnum, when the subcommittee was constituted, it started carrying out the exercise. Since there was a complete lull, nothing was moving. Techno Power was not interested, and I was very much within the justified ranges because my lower bid was not rejected. Since Techno Power did not show any interest, I submitted a my lord representation. I submitted a representation on 21st November 2024. In my list of dates, my lord will find that.
Where is it?
21st,
22nd, 21 January.
21/11,
No,
24. This is page 215 and 216 of the writ petition. I urged kindly analyze it. I am very much within the justified range.
Now, what is this 222? 22/1/2025 representation?
Oh, yes. My lord, this I have already placed.
No, this is
that-
your representation, 22/1.
My lord, 22/1. Oh, that is subsequent, my lord. This must letter, my lord, before that.
Okay, okay.
Before that in page number 3. On page number 3, please.
Yes, yes.
Page number 3.
215.
Yes.
215.
My lord, kindly page number
page-
3
page-
of the list of dates.
Page 215 of your writ petition.
Page 215, correct, of the writ petition.
You had submitted a
Representation. I said Techno Power has not come forward. Wind Power already out of the picture, lowest bid. I am justified range. My bid was not rejected. Please reconsider it. Analyze it. It's in the range. Then on 26th November 24, the Chief Engineer Power wrote a letter to Superintending Engineer asking him for comprehensive re-evaluation. At page 217 of the writ petition, my lord, I'll take my lord to. Annexure 14, page 217. Now, Chief Engineer Power himself is the person, my lord, who was also in charge of the subcommittee. Now, the same gentleman, my lord, forwards my letter for comprehensive re-evaluation at page 217 of the writ petition. Subject reminder and request for re-evaluation of financial bid with implementation of minimum and maximum justified rates for Pasighat RDSS package. So comprehensive analysis, minimum and maximum justified rates. Representation dated such and such is the reference. With reference to the subject cited above, please find enclosed a representation from Messrs. DG Construction highlighting alleged discrepancies in the evaluation of the financial bid for the Pasighat RDSS package. The representation states that the tender opening and evaluation committee under your chairmanship erroneously recommended a bidder whose quoted rates fall outside the justified range prescribed by the government. This alleged oversight raises concerns regarding compliance with the evaluation criteria and fairness in the tendering process. Such matters necessitate immediate attention to such and such. So he writes a letter. Accordingly, my lord, re-examination is carried out. Tender opening board does it, and tender opening board thereafter gives its recommendation. It is dated 3rd January 25. 3rd January 25, page 218 of the writ petition. Complete re-evaluation. Enclosure is the re-evaluated comparative statement signed by all the members of the board, chairman being superintendent, e-tender opening board. They analyze, my lord, the entire thing, and para 5 is important at page 218. Para 5.
Considering.
Yes.
Considering.
Considering the item-wise analysis and assessment of average deviations shown at column 26, 30, and 34 of the comparative statement, the deviation of Messrs. DG Construction, average deviation on supply is minus 0.39% and reduction is such and such from average justified rate. Messrs. Wind Power, such and such. Techno Power Enterprises, such and such. Thereafter, references made to the pre-bid meeting, 8923 memorandum, justified ranges, then earlier recommendation, then the last portion, in view of the above.
Yes.
And upon re-evaluation, the price bid of Messrs. DG Construction Naharlagun is found to be least deviated from the average justified rate as per the minimum and maximum justified price ranges approved by the government and hence recommended for approval, please. So, my lord, this recommendation in my favor was on 3rd of January 25. After 3rd of January 25, the only thing happened was possibly the subcommittee exercise. And that is all behind our back. We were expecting letter of intent after 3rd January 25 recommendation. Instead, my lord, the letter of intent was issued to respondent 9 by 15th January 25 letter of superintending engineer. So, my lord, this is what the broad spectrum of the case is all about. Now, my lord, I have only 3-4 submissions to make, my lord. The law is well settled. My first submission, my lord, I place my reliance on the well settled principle, my lord, laid down by my lords, my lord, in the famous R.D. Shetty versus International Airport Authority. When you profess or standard to be judged by laying down certain guiding principles, because you have your parameter of 8923.
You have got a list of books?
Yes.
Given.
This was given. The International Airport Authority, my lord.
Ramanna.
Yes.
You need not give the entire.
Lordship knows the principle, my lord. I just only that that is, an executive agency must be rigorously held to the standards by which it professes.
What we or at least our court is requesting that while giving the citations, you can give the first page and the paragraphs which you are relying upon.
My lord,
we don't want wastage of paper. We have copies in our
In future,
with us. That will help the
yes.
client, the lawyers, the court also, unnecessary burdening of the file. Necessary.
I'll
But
remember.
first page is very important and the paragraphs, those pages of which paragraph you are relying upon. Rest
Yeah.
you can, and if there is any other paragraph, the other side to rely, they'll say that this is the other paragraph.
In future, my lord, I'll do that. That's
We are thinking that is
I'll
convenient.
do that in future. So, my lord, the relevant paragraph is AIR 1979 Supreme Court 1628, para 10 is the relevant paragraph. The loaded sentence is this particular sentence. An executive agency must be rigorously held to the standards which it professes its action to be judged.
Just a minute, please. 459.
Paragraph? Paragraph 10. My lord, after the quotation of that Justice Felix Frankfurter from the Vittorali versus Sito,
Yes.
that famous phrase, para 10, it is a well-settled rule of administrative law. Lordship, take my book.
No.
I marked it.
No, it's
Para 10 of AIR. It is, my lord.
AIR or SCC.
My lord, I'm reading from AIR. In fact, the old days.
Doesn't matter.
My lord, it will be easy.
We'll
Very convenient.
We'll mark this, mark here. We'll return this. Para 10.
Para 10. In Supreme Court.
Yes. After Frankfurter.
Yes, but Justice Felix Frankfurter's entire quote from
Thereafter,
Vittorali versus Sito,
yes.
then executive agency must be rigorously held to the standards.
Yes.
That's the famous quote. Now, my lord, this principle was lastly reiterated in 2025 1 SEC. Very latest judgment. 2025 1 page 695 at paragraph 80. Kirloskar Ferrous Industries Limited.
1 SCC 625.
Yes, my lord, it is relevant. The judgment starts from page 695. Relevant page 726.
Paragraph
80. Same principle reiterated. Before that also, there is another para referred to from NBCC case, para 80, equally relevant. But para 80, they have reiterated the International Airport Authority principle. Then, my lord,
just a minute. 80, paragraph 80. The Ramana has been quoted.
Yes, my lord. With approval.
Okay. Executive authority must be rigorously held. Yes.
Then, my lord, Jagdish Mandal, 2007 14 SEC 517. Jagdish Mandal versus the state of Orissa. The relevant para 22. The two guiding principles Supreme Court referred to. One, to test the legality and validity of the decision-making process. Whether the process adopted or decision made by the authority is malified or intended to favor someone. We say it was intended to favor respondent 9. And whether public interest is affected. On public interest by submission would be if someone is rejected on the ground of being abnormally low, by tinkering, you end up the bid of such a person, it would automatically affect the public interest. Yes. That's the principle, service standard naturally. And then lastly, my lord.
This paragraph 22 has been extracted in many.
Yes, my lord. Well,
which you can
yes,
revert
my lord.
verbatim.
Yes, my lord, in fact, on so many occasions in other judgments, I've referred to that. And lastly, my lord, my last submission, changing rules of the game midway. Though, my lord, the principle was laid down in Tej Prakash, it's a service law jurisprudence, but my lord, it's also part of the administrative law.
Now it has been answered also by the full bench.
Yes, Tej Prakash, the judgment is reported in 2025
On the date
to
of
SEC. Yes.
the date of the retirement.
Yes, my lord. That's it. That's it. Justice Roy was party to it.
Five important judgments.
Yes. Para 65.2.
Tej Prakash,
Tej Prakash.
give the citation.
Citation is 2025 to SEC, page 1. Para 65.2.
This SEC.
Yes, my lord.
2025.
To SEC, page 1.
Para.
Para 65.2. So practically, my lord, if we look into the entire evidence, it appears that selectively, my lord, when power was pushed up by applying the recommendation of subcommittee. Whereas in respect of the others, 18.923 principle was followed.
60, para?
65.
Paragraph will change maybe. 65.2.
Because in SEC online, my lord, in fact, SEC online, my lord, SEC online, there will be difficulty in paragraph.
How will it start? You tell us.
65.2.
Conclusion are you reading? Conclusion?
Yes, my lord, conclusion.
Number 2, eligibility criteria.
Yes, eligibility criteria.
42.2.
For being placed in the select list.
Equivalent is 42 to.
Oh, that is it.
Doesn't matter. Manjushri was held to be good law.
Yes, correct. Manjushri was held to be good law. Yes. In SEC online, it will for being placed. Correct. 42.2. Here it is 65.2. In SEC. Basically, we know administrative law principle. They applied it in service law, holding Manjushri to be good law. So, these are my submissions.
But one hurdle you will still have to cross regarding somebody above you.
Yes, techno, but techno never came, my lord. That's the whole difficulty.
No, suppose you are successful in your venture.
Oh. My lord, we filed an RTI application. These are subsequent developments. It's not on the board. Just now we got it. We filed an RTI. The answer is serial number 6, present status of the validity of Techno Power Private Limited in RDSS package in Pasighat Electrical Division. The bid security earnest money of Messrs. Techno Power Enterprise Private Limited, Kolkata, has already been released, wide number such and such, dated 31st January 25. It was released on 31st January 25.
No, suppose, Mr. Tiwari, you are successful in your endeavor to convince the court. We pass an order for, we cannot say that you give it to you. We can only say that give it to the eligible bidder as per following 18.9. That more than that we cannot perhaps say.
That is, we are agreeable to that. We understand our limitations.
That will depend after we hear.
Yes,
the
certainly.
Department
My esteemed colleague
who has defended, and thereafter Mr. Das.
Yes.
Who is the beneficiary?
We are not seeking mandamus saying that we should be, but we say you follow 18.923 only. Don't follow recommendation of the committee. That I have shown to my lord.
Yes, Mr. Parme.
I will directly start with my affidavit in opposition, my lord. That is affidavit in opposition, my respondent 1, 2, 3, 4, and 5 and 6.
Yes. Page,
Page, my lord, page 325, my lord.
your standing counsel power,
My lord,
325.
25, my lord.
You filed your affidavit on 25th of April 2025, right?
My lord.
Three twenty-five,
My lord.
yes.
This is my
Annexure E.
E, my lord. My lord, will see, my lord, this is auto-generated, my lord, detail, my lord, or the tender, my lord. My lord, one, my lord. This is wind power infra private limited, my lord. It is around 46 crore, my lord. Now take no, my lord, 2 is my lord, 52, my
This
lord.
is after the subcommittees.
No, my lord, before, this is auto-generated, my lord. Because generated from the computer, my lord, before,
On the evaluation of the final.
before
Yes,
evaluation of the, my lord.
yes.
My lord will see, my lord, petitioner, my lord, at serial number 3, my lord, it is 54, my lord.
Hmm.
On next page, I invite attention of my lord at page number. No, from page number 336, my lord, this is annexation number 4, my lord.
336.
336, my lord, annexation number F, my lord. This is manually, my lord, carry out tender evaluation, my lord, seat, my lord, by the committee, my lord. Page number 340, my lord, will be relevant, my lord.
Three four zero.
340, my lord. Here, my lord, will see, my lord, pass, my lord, at column number, my lord, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. 11, my lord. Starting from 11, column 11. This is of petitioner, my lord. His quoted amount is without tax, my lord, 54, around 54 crore, down below. Last row, my lord. Grand total, my lord. And with tax, my lord, it is 64, my lord. 64 crore, there are 64 or 32 lakh, my lord. Now, second row or column, my lord.
What is 64 where without taxes 85?
64, my lord.
Where do you get?
At column
number 11.
13, my lord.
13.
Column number 13, last row, my lord.
Last row.
Last row, my lord.
99. Nice. Serial number 99 or what?
Yes. Serial number 99 and down below, my lord. 64, my lord. This is grand total, my lord.
Grand total. Where do you get grand total? Grand total. You are in page number 340.
340, my lord.
Yeah, 340. The last row is 99, isn't
99,
it?
my lord.
Which row are you saying?
After 90, last row, after 99, second row, my lord. After 99, there is 2 row, my lord. Total of election, grand total, my lord.
The grand total, yes, that is in 341.
Grand total, my lord, will see of the of the petitioner is 54, my lord, without tax, my lord.
54, yes, so you're right.
Yes.
That is a 341.
Yeah.
Page 341.
341, my lord.
Petitioner. Yes.
Now, here also, my lord, the private respondent 9, my lord, with tax, my lord, without tax is 4659, my lord, 46 crore, my lord.
Yes.
And amount with tax, my lord, he is 54, my lord.
Yes.
Now, now, my lord has seen the situation, my lord. In terms of my lord, yes, my lord, in terms of this tender quoted by the bidder, my lord, undisputedly this private line number 9, my lord, was the L1, my lord, lowest bidder, my lord. Now, my lord has seen all those documents in the writ petition, my lord. There is a series of complaint, my lord, by the petitioner, by the private respondent also, my lord.
Complaints regarding?
Complaint regarding recommendation of this techno power to be awarded work, my lord. There's a complaint by the both by petitioner and the respondent.
Against techno?
Against the techno. Earlier, by this page number 4 the techno was recommended, my lord. Page number 341, my lord. We'll see. In view of the price, MS Techno Power Enterprise Private Limited is bound to be lowest as per a minimum and maximum justified, my lord. He was recommended, my lord. So there was an objection from both sides, my lord.
Yes.
And according during the process, my lord, in between there, my lord, in the other area also, my lord, there's objection, my lord, like in Namsai, my lord, Rupa, my lord. Already by the order dated, my lord, 22 March 2022, my lord, as constituted, my lord, in the pertaining to the Rupa package, my lord. Now, when there was a serious counter claim on the part of those parties, my lord, the farm, my lord. Accordingly, in the given situation, my lord, the authority, my lord, has constituted this board, my lord, for regulation, my lord, to look into the complaint and counter complaint of the
Where is the complaint? Now, the constitution of the subcommittee, does it reflect that it was done after complaints?
Yes, my lord. Yes, my lord. My lord, kindly have a look at the noting, my lord. I have also enclosed my in dear writ petition, my lord. Writ petition, my lord, will see no. Starting from my lord. Starting from as annexation of 18, starting from
Writ petition?
Writ petition, my lord. 227, my lord.
227.
My lord.
Yes. 227 is a minor submitting.
My lord.
No.
Page number 230, my lord, would be relevant, my lord. 230, my lord. Note number 3, my lord.
No, the simple query from this code is that by following this 18/9/2023,
My lord.
when you have found the bid of the respondent number 9 to be abnormal, it was initially said
Yes.
it is abnormal bid, we cannot consider, but still there was a move to seek justification.
No, my lord, in abnormally low can be considered, my lord,
No,
in
no,
the
as
tender.
per 18/9 itself, so you had made a move
My lord.
asking that justification. Will you be able to do, how will you be able to do it with such abnormally low rates?
Yes, ma'am.
That process of that exercise was done by this letter of 12/3/2024, and it was, the exercise had culminated into a rejection, which was informed to them. Then this matter was also taken to the e-tender committee.
Right.
E-tender opening board had also rejected on 22/3/2024 at page 211 of the writ petition.
211, my lord. Yes, my lord. This is the same tender board, my lord.
Yes, by the e-tender opening board.
Yes,
Now,
my lord.
after such rejection of the attempt to justify, where is the scope to again reopen the matter? That is one question.
Yes, my lord. I do consider some deviation, my lord. In this case, my in this the
No, we
situation
have-
before the authority.
We have not even put the question whether only this package was considered, others were not considered. At least three of the instances Mr. Tiwari has quoted. You have adhered to the initial guidelines of 18.9. You sought for justification, not justified. You followed this, but we are not even in that question. We are on the question that after an exercise was conducted, giving them a chance to justify, justification given, rejected initially,
Yes.
informed, then again the matter was taken up by the e-tender opening board.
Yeah.
Opening board, the board rejected on 22/3/2024. Where is the further scope to reopen the entire thing? You send somebody to Kolkata. Because your decision has to be lawful. You may justify it's a sound decision. I send somebody, but we are not going by the soundness. We'll go strictly by in accordance with law. What the law permits will be looked into.
No, my lord.
Your personal satisfaction may not be of much value.
Well, I'll put the situation in this way, my lord. Situation before the authority, my lord. There is, yes, my lord, guideline in term of previous meeting, guideline was supposed to be eligible. That was applied, my lord. Now, on the record, my lord, will see, my lord, this preparation and L1, my lord. So while recommending, he was not given a chance to justify those date, my lord. That is situation, my lord. Now, when this situation reached before the beyond the technical evaluation board authority, my lord, all the other comprehensive, my lord, like in Namsai was there, my lord. There is complaint of Namsai inside also Rupai, there in Nahalong also there. Now, in such a situation, my lord, authority, my lord, in the interest of public, my lord, ultimately, if my lord see when there's competition, my lord, suppose if I able to execute the work, my lord, by the lowest bidder, my lord, that will surely beneficial to the public for the public, my lord. Now, in such a situation, my lord,
Mr. Parme, we are concerned that state exchequer is one of the prime consideration.
Yes,
But that cannot be at the cost of the quality of the work. It cannot be at the cost that quoting an abnormally low rate, one bidder is not able to even do anything, leave
Yes.
the work halfway. Those are matters which were taken into consideration before framing the guidelines of 18.9. And these are not new phenomena. This has been going on for ages. We find that abnormally low rates are quoted, works are abundant, works suffer in their quality. So these kind of guidelines, after many deliberations, have been framed that yes, it has to be within a particular range. If it is beyond a particular range, then you will be asked for justification. You justify, yes, with this rate I can do it. How? You justify. If the justification was found to be having some basis, they will still allow the work. And in matters we have found in certain departments that additional performance security is asked for if the rates are abnormally low. Give it to you, but you have to give us additional performance security that in case you fail, this will be forfeited.
yes, my
This
lord.
is not here, but we are only on the aspect that exercise was done. It was initially rejected, opened, justification asked for, rejected. It went to the e-tender opening board, again examined, rejected. Thereafter, where is the scope of again reopening the entire thing? And that to doing it privately.
Yes, my lord. That's why, my lord.
Now, where is the first scope of having a subcommittee to reevaluate the financial bids?
Yes, my lord. Only is that it does. I humbly believe that is the sole issue to be decided by this honorable committee. ultimately in given, in a given situation, my lord.
No, you show us the source from where you could form a subcommittee after the matter was put to rest.
Yes, my lord.
Where is the source?
My lord, yes, my lord. I do concede, my lord, in term of term of the NIT, my lord, that is not there, my lord. I do consider that.
If
But
there is
in
no
a
source,
situation,
how, it is not a private thing.
yes,
You
my
are a
lord.
state, you have to be open.
Therefore, my lord, my humble submission, my lord, in the given situation, my lord, whether this exercise, my lord, constitutive subcommittee, my lord, by the competent authority, looking into the whole aspect of public interest, where this is such to be held in as an arbitrary and malapite in a such an extent, my lord, where is intervention of this honorable court is necessary or not, my lord. So I try to impress my lord upon my lordship is my lord. Yes, my lord, some deviation is there in this case, my lord. But was in the demand of the situation, my lord. It is not a single out case of the petition in the Pasiat case, my lord. There's a series of complaint, my lord. On the my lord, this complete this viability of this our notification, my lord, 89 to 2020 notification, my lord. There are a series of complaint, my lord, in so many area, my lord. Now, in a such situation, my lord, my humble submission, whether I am putting a question to myself, my lord, to the competent authority, is so helpless, my lord, to not to address those, my lord, issues, my lord, and look into those address, my lord, taking into the public interest, my lord. So my humble submission in it was a case, my lord, where there is a series of complaint, my lord, by the in other area also, my lord. So as my lord, when this issue of the Pasiat area, my lord, already there was a order by the or already subcommittee constituted, my lord. Accordingly, my lord, that was placed before the competent authority, my lord. The government decided, yes, you look into those also, my lord. And after matriculation analysis of the laws,
We want a very categorical answer from you.
my lord.
Does the process which emanates from the notice inviting tender and the tender document, does it envisage forming of a subcommittee to reevaluate the financial bids after it was rejected by the e-tender committee? You want a straight answer, yes or no?
No, my lord, that is not in that NIT.
But you are trying to justify that it has been done in the interest of public.
Public, my lord. Surely, my lord will see the whole report also, my lord. There was a metrical analysis by the committee, my lord, on the taking into market, my lord. Now they find, my lord, this though earlier they are declared abnormally low, my lord, but in terms of the nearest market, my lord, available that is Kolkata, that can be carried by them, my lord. Accordingly, this committee submit the report to the government, my lord, and the government decided to approve this, my lord. Now, other one aspect, my lord, in the epidemic reply, my lord, this, my lord, was not error in the other case, my lord, by the petition. That is not true, my lord. Yes, my lord. Like in Rupa, my lord, in the Itanagar, my lord, other recommended by this committee, my lord, has given awarded, my lord. But it was in the given situation, my lord. Like in Rupa, my lord, before the L1 by lowest bidder, my lord, withdraw the EMD, my lord. And in other case, also in a given situation, my lord, when, my lord, those, my lord, recommended by the subcommittee, my lord, decline to accept the offer and they withdraw from the tender process, my lord, this other were given, my lord. Otherwise, my lord, I am on record, I am submitting, my lord, we are still either and go with this committee report, my lord, subcommittee report. It is not case, my lord, in other case, we did not apply this committee report, my lord. Let us apply in the other case also, my lord. But yes, in given situation, my lord, those other than the L1, my lord, award the contract, my lord. Well, I believe, my lord, I not need to read those report by the committee, my lord, in the
If you think you have to read which one?
only I would say about this, my lord. I find this committee report, my lord, as a meticulous, my lord, exercise, my lord, in a given situation, my lord. My lord, kindly have a look at my at page number 357, my lord. This is
Yes.
here also, my lord. It note that whole they have analyzed also the in terms of justified rate also, my lord. Say one turnover is the Pasigat package, my lord. Pasigat package, my lord. They have analyzed in terms of their code in terms of justified rate and my lord, see, my lord. Pasigat package, abstract of analyze, my lord. 357, my lord. This is D NG construction petitioner, my lord, is she his quoted 65.33 lakhs, my lord. 65
Let us
crore.
see by which order you had formed the subcommittee.
From the at page number, my lord. 343, my lord.
343. Do you have the file by which led to formation of this committee? Original file?
Yes, my lord.
Please,
Today I have looked at like
You have to produce this. You get it tomorrow, but today we are going to complete this. How was this committee formed? What were the consideration?
earlier, my lord, in this case, particular case, my lord, there was also a read petition before this, my lord, my lord, pertaining the Rupa package, my lord.
Okay, then
Then, my lord, this before we file, my lord, any epidemic in opposition, but this committee was on the, I can only recall that about the whole other pack, my lord, I need to recall what to record. But in here also, my lord, you kindly have a look at page number 357, my lord.
three fifties?
357, my lord.
Yes. That you have already.
Yes, my lord. Here, my lord, I am showing this, my lord, to impress impress the fact that, my lord, that ultimately in respondent number 9, my lord, in terms of the computer auto generate comparative chart, or in terms of the manually prepare, or in terms of this analysis also, he used the L1. Now he respondent 9 is the L1. Now when it in terms of market analysis also, my lord, this, my lord, by this work, my lord, or by under this amount, this can be carried out, my lord. So on those basis, my lord, I find this committee report, my lord, as a meticulous, my lord. It therefore, my only submission would be, my lord, yes, my lord, it is a case, my lord, where, my lord, in a given situation, my lord, on the interest of public, my lord, a decision was taken by my lord by the all this competent authority, my lord, to look grievance, my lord, particularly taking into public interest, my lord. So when such, my lord, if that, my lord, authority, my lord, is absent in NIT, my lord, can those action, my lord, can be term in such come with the purview, my lord, in such arbitrary in malapide, my lord, that require interpretation of court, my lord. My humble submission, my lord, until in some malapide or arbitrated directly linked where that directly indicating some favor to the some party, my lord will not exercise, my lord.
But your actions smacks malice, legal malice. Where is this power to, where is the source of power to form a subcommittee? Number one. What is the role of this tender opening committee, which came to a conclusion at 204? Was it a matter of challenge before anybody? Why was it redone?
Yes, my lord, that's why I am something, my lord. Where
No,
this,
when in 204, you had said that R9, this bid has been rejected. And one techno was declared as L1, petitioner as L2. Matter is not, has not come to an end. You still ask for justification from R9, justification given, rejected, reconsidered by the higher committee, rejected. Thereafter, well, how long will this process go on? Go on the desired result?
no, my lord,
It appears so, that unless I want my desired result, I'll go on reviewing.
no, my lord, the situation in the past subcommittee, my lord, was ordered in March 2024, my lord.
Okay, Mr. Das.
May it please your lordship.
Just a minute. Beleg color pen আছে নাকি? Green ছিল? Green thing pen আছে নাকি? Beleg color? নাই না? Pen. Black তো আছে মোৰ তাত। Black, red, blue, green নাই না? ঠিক আছে, হ'ব। Okay. R9.
Yes.
Yes, please.
But my scope of argument will be very limited. And I will concentrate my argument on the basis of the affidavit which is filed by the government to that
Yes,
extent.
yes.
I will not go beyond that.
Yes.
4-5 dates are important, which I find. Because what I understand from the argument of my learned friend is that NIT was floated. And when the NIT was floated, there are two big systems, one is techno-commercial and one is financial bid. Now there is a standard bidding document and there is a memorandum of 18/9/2023.
Correct.
Whatever it has to be done, it has to be in accordance with these two standard bidding document and also 18/9/2023.
Guidelines.
We go back to guidelines. Now that is also one of the issue which I would like to address.
Please.
18/9/2000 go backs again, my learned friend argued, said that there are two clauses, 36.1, 36.2 and 36.3. Where, my lord, if it is abnormally low, then there an opportunity has to be given to the bidder. Now, in the first instance, what I have seen from the writ petition, an opportunity was not given to the bidder in the very first instance. Superintendent engineer, when the records came
to the petitioner or to the R9?
To R9.
R9.
Subsequently, it was given. At the very first instance, when this technical bid was opened, your lordship will kindly note that date, which was initially it was rejected. Technical bid, techno-commercial bid opened on 26 February. And on 12th of March, if your lordship kindly see 205. 205, this was below abnormal, it was rejected accordingly.
Yes.
Lordship got it?
Yes.
So immediately on that day itself, 12th of March 2024, at page 206, we have written to them for giving opportunity. If you see at 206 on an 8 page,
306.
206, 205 is a rejection without giving any opportunity to us.
Right.
205, that is 12th of March 2024. It was rejected.
Yes.
Then if you see to 206, next
Yes,
page,
please. Yes.
then immediately on the same date, we have asked, requesting them to give opportunity. If you see this to justify the abnormally low rate, which they have rejected. This is at page 206. That is 12th of March 2024. If your lordship kindly see on the left-hand side of the column, 206, 12th of March 2024. Request for giving offer submission of price justification as per SBD. Lordship got it?
Just a minute, please.
Yes.
This is your letter.
My letter. This is my letter.
This is dated.
This is 12th of March 2024. The day when they rejected it, on the same date we have requested them for giving an opportunity, 12th of March 2024.
Yes.
Now, if your lordship turn to page 207, number 2, 2072. That is 2072. As regards the price quoted 2. 2072.
Yes.
The price quoted by is very genuine competitive, as we have considered only 10% profit, and if you require, we can share the same with the quotation of best OEM. It is also imperative to state that we always procure project material in bigger scale and mass volume on regular basis. As a result, our vendors offered us very competitive price. As such, our quoted rates are workable according to prevailing market price. So, lordship will kindly note down
Yes, yes.
as prevailing market price. Now, if you see after 5, most important, we also submit contract performance guarantee at the time of execution of the contract agreement for timely and satisfactory completion of project. After completion, again we'll submit a bank guarantee against warranty period. Please turn to page 208, third paragraph.
208.
208, third paragraph. However, we will find our price justification aligned with your expectation. However, if you need any further clarification, 208, third. However, not the first, second. However, we will find 208. However, hope you will find. Hope you will find.
Yes.
Our price justification aligned with your expectation. However, if you need any further clarification, then we are ready to provide the same as per your convenience schedule. The major factor for the difference between your minimum price range and our quoted price is profit margin. And if you are ready to execute the project by taking minimum profit of 10%, so we don't think that we have any problem if you deliver the project by saving 10.25% more amount beyond your expectation. It is out of the point to mention here that we associate with the ground of more than 20 years, and we better know how a project will execute in the land. So this is the explanation which was given to them. In the meantime, if you see at page 209, the chief engineer has written to superintendent engineer that at least before rejecting, you should give a chance to R9.
Yes.
Now, before that, my 12th of March 2025 or 24, we have given an explanation.
Yes.
Before that. Now on to 209. If you read, kindly see at page 209, just want to read this 209. Now, it has come to our, please 1, 2, 3, 4th line. It has come to our attention that the firm quoting abnormally low amount, Messrs. Wind Power Infrastructure has not been afforded an opportunity to justify their low quoted rates under clause number 36.2 of the standard bidding document. It appears a tender opening committee rejected the bids under clause 36.3 of SBD without conducting a detailed price analysis of the bidder. So this is what my lord, the chief engineer, how you reject it, you should have given a chance to them. And accordingly, I read my lord 206 onward. On the same day on rejection, we have given an explanation giving details of it. Now at page 211, now this was rejected. Now rejection is, my lord, not a reason one. No doubt we did not.
Just a minute, please.
Yes.
211.
211, see the second paragraph. Is what they are saying. You have, may I read?
Yes.
We have quoted 5498 73 154 against so and so put to tender, which is minus 16% below the estimate cost put to tender and minus 10.25% below the minimum justified rate as per memo dated 18/9/2023. My lord, they are relying on an office that's memorandum, which my learned friend has shown, which says of the government of Arunachal, which is abnormally low. We may also refer our pre-bid meeting minute so and so. It has clearly mentioned justified bid price ranges approved by the high-level technical committee as circulated by above main memorandum will be taken into consideration at time price bid evaluation of the bidders. Your price bid has been rejected by the tender opening tender. So what he says that your price bid cannot be accepted on the ground that there is a memorandum of 18/9/2023 and we have considered that and we have looked into it.
Yes.
And we find this is a rate which is not viable. This is what I understand from his letter.
Correct.
This is what he said. Now, my lord, thereafter, I don't know trouble. 212. Now, superintendent informed the chief engineer now. Ground A and B, if you see at 213, this is a letter which is addressed by superintendent engineer to chief engineer, because chief engineer has written to the superintendent, you have to give a chance to them. And ultimately, rejection order, this is why it is not acceptable. This was informed to the chief engineer at page 212.
Yes.
212, these are the 213, 1 and 2. 1 and 2. The ex-work prices of major line material from various Calcutta as given by so and so is in justification letter are much lower than the ex-work price quoted by the approved Calcutta from the same kind of material submitted to this office in response to our request copies. Therefore, it raises material concern as by quoting unrealistic low bid. Bid if awarded, the project may compromise with the overall quality of the product and works that may lead to failure of the project. Now see 2, price bid quoted by so and so is minus so and so in the pre-bid meeting held so and so in response to the query. It was calculated judicial justified bid price of so and so as approved by high level technical
Okay,
committee.
we'll continue at
Yes.
2 o'clock. We were in 213.
213, yes. 213, where these are the the superintendent engineer returned back to the chief engineer and informed the reasons why it was rejected, which I have read, my lord, 213. And now, if your lordship kindly look into, this is 26th of April. Please note to 26th of April,
Correct.
212.
Yes, yes.
And if you see 214, it is 13th of November 2024. Why? Kindly see this particular, there is a delay about 6 to 7 months. There is a gap in between. April, then November 2024. That's your lordship was asking a very pertinent to question to my learned friend who representing the government. Why this 26 to 13th of November 2024? Kindly see 13th of November, he informs the petitioner, superintendent informs.
This is 13th or 18th? 13th.
13th, I think it's 13th, 13th November.
13th.
In the petition, I think they written 13 November.
13th. Okay.
13. 13 November.
Page 214.
214. Now from April to 24, this November, nothing has happened in between.
What is this?
Now what I found.
What is this 214?
214 is a letter by superintendent to DG Construction.
To the petitioner.
Yeah, to the petitioner. With reference to a letter so and so has already been done by engineering board and the same has already forwarded to chief engineer so and so for obtaining approval from the competent authority. This approval from the government is still awaited. So they have sent the letter forwarded on 26/2 forwarded so and so for obtaining approval from the competent authority. But your lordship will kindly find that this after rejection was my bid was rejected. If your lordship looks at 12th of March 2024 at page 205.
Yes.
And this we find 214 letter which addressed to the petitioner and they said we have already forwarded to so a chief engineer power central so and so dated 26th of February 2024 for obtaining approval from the competent authority. Approval to government is still awaited. So I think the approval is already they decided that we should give this particular tender to DG Construction. But in the meantime, they might be.
Where is this letter of
26 to
no,
2000.
no. 26 is there at page 204.
205 is
189. 189.
Yes.
189 minutes in.
Yes.
So where is this letter of 7/10/2024?
7.
If you come to 214.
214.
The letter which you have just read, 13/11/2024.
Yes.
This is in reference to a letter dated
7/10/2024.
7/10 appears to have been addressed by the petitioner because this response is to the petitioner.
Yes.
So is there any?
We don't, I don't have that. Neither I have not seen my learned friend will be able to respond to that letter because that reference is 710. In pursuance to reference only this was said.
You're right.
Pursuance.
Yes.
So I don't have the letter. I don't know what is that letter about. Reference. Because when I read this, my lord, read petition, at 212, I thought that why they have taken so much of delay. 26th of April 2024, and this was 13th of November 2024 at 214. Lordship got this? 214. And reference I don't have. My learned friend of a representative government will be able to tell what is that letter of 7/10/2024. Now, my lord, after that, I'll tell what has happened in between on the basis of the affidavit that has been filed by the government.
Yes.
I'll project, because on the way, that's why I said, I'll rely on the affidavit which has been filed. Because your lordship was asking a very pertinent, a question that was asked. The subcommittee. Because you have to go by the standard bidding document as per the memorandum of 18/9/2023. What to form a subcommittee
Yes.
and re-evaluation committee.
Yes.
So your lordship was asking very pertinent, how you have done subcommittee. What I have seen from the affidavit that has been filed by the government,
Yes.
please look into 266 now, page 266. Of the affidavit filed by the government.
Yes.
266, the subpara,
Yes.
the tendering process, they have explained now, my lord. Tendering process began on 17/1/2024, and a tender opening and evaluation committee for so-and-so, Pasighat, chaired by so-and-so, recommended Mrs. Techno Power Enterprise, Kolkata, for the award of a tender letter dated 26th of February 2024. However, in light of multiple complaints, writ petition before this honorable court concerning the Rupa package, the government constituted a re-evaluation committee on 29th of May 2024 to conduct an independent review. The committee submitted a report on 15th of July 2024 recommending bidder based on a market rate analysis rather than the earlier justified bid ranges which were ruled out by the committee. Now, what we found, my lord, there is a writ petition which has been filed by one Rejoinder found in respect of Rupa package. When they mentioned about the Rupa, the writ petition was filed, we tried to get that copy of the writ petition. What is about the writ petition? Now, if your lordship looks into it, the first order, kindly see, 3/5/2024 order.
Yes.
I think my learned friend, Mr. Sharma, he appeared, who has filed the instant writ petition under Article 226 for setting aside the memorandum dated 18/9/2023, which is the minimum justified rate amount prescribed. So now today, well, his argument is that you support the memorandum, but here he said the memorandum should go. Since the instant memorandum was not referred at the time of NIT number dated 1/8/2023, because there are different NITs which was floated regarding about the package scheme. Scheme is a central sponsored scheme. The last date of submission of tender, while the impute memorandum came just before the last date, and therefore everything came disadvantage. Hard submission so and so at the appropriate so and so. However, requisite extra copy, the prayer for interim order. Now, the next order will kindly look into the next order. It will. Next order, 39/2024. Lordship got it? Now look into 39. The Learned Counsel submits that the state authority has referred the matter by constituting 3-member committee to examine the issue involved in the present writ petition. However, as on date, no speaking order or report has been made available, putting the petition in limbo, despite the fact that the committee was supposed to examine the issue within a time frame of 15 days. However, considering the state has already constituted a committee consisting of 3 members with clear terms of reference with regard to the issue involved in the petition, for passing a speaking order by recommending the acceptance or rejection of bid within a time frame of 15 days, so and so shall on so. So now thereafter there is another order which your lordship will find on 39. It's the same order. 410. Kindly see the order of 410. 410, so and so constituted by the committee for re-exam process and to recommend for accept or rejection of bid in question directed, peruse the copy of record. I deem it able to allow 4 weeks time to say to take a decision of state report. Copy of the report is kept on record. So as directed by this court, my lord will kindly see on the second paragraph. Constituted by government for re-examination process and to recommend for acceptance or rejection of the bids in question as directed by this court on 39/2024. Copy of report is marked as annexure so and so, so and so. Now thereafter, we came to know that they have withdrawn the writ petition once the report was furnished. That's what my information. My learned friend, Mr. Sharma, was handling the case. He will be able to project before, or rather say that whether it has been withdrawn or not, this case. Now, there was an order passed by the court. A report was furnished. A 3-member committee constituted, and I have seen that how the committee was constituted, having a knowledge or background of technical, legal, as well as financial. This particular. Now, that is how they explain in 266. In between, what has happened, my lord? 17, my lordship, kindly see again 266. See, Papa, kindly see 266.
Yes.
The affidavit.
Yes.
Now, tendering process, I've read. However, in light of multiple complaint, writ petition before the Honorable Court, the government constituted a re-evaluation committee on 29th of May to conduct an independent review. The committee submit report recommending bidder based on a market rate rather than the earlier justified, which were ruled out by the committee. So, my lord, this is what they receive multiple complaints, not only in respect of Rupa package, in respect of other packages also. Abnormally low rate was given. Now, my lord will kindly see. Next paragraph. Following a detailed review of the finding, Government of Arunachal Pradesh, after due diligence, approved 267, my lord. Approved the re-evaluation committee recommendation on 8th of January 2025. Leading to the issuance of letter of intent to the lowest responsive bidder, Messrs. Wind Power Infra, on 15th of January 2025. This decision was made in the interest of public fund and government governance, ensuring cost efficiency, adherence to procurement regulation. Thus, the petitioner claimed authorities unfairly reneged on an earlier recommendation is factually incorrect and legally unsustainable. The final decision was based on a structured, transparent and legally compliant evaluation process, ensuring fair competition and physical responsibility. Now, my lord will kindly see how they have answered to it. We'll see at page 270. See now 270. Now, kindly see 270.
Just a minute.
Yes, yes.
$270.
Please see 270.
Please. Yes.
The petitioner is fully aware bids for 6 RDSS package, Namsai, Naharlagan, Itanagar, Rupa, Deomali and Pasighat were placed under scrutiny by the re-evaluation committee. Pausing for a moment, my learned friend has shown these packages were earlier, and subsequently this Rupa, the Pasighat package were included. Subsequently, that is what it report it says. This committee was constituted by the government of Arunachal Pradesh on 29th of May 2024, following multiple complaints from bidders and a writ petition filed by joint account before this honorable concerning the rejection of bids under the Rupa package. After reviewing the matter, Commissioner for Government of Arunachal Pradesh raised concern over rejection of auto-generated L1 bidder based solely on the justified bid ranges, which necessitated a more detailed evaluation to ensure fairness and compliance with procurement norms. Consequently, for the sake of uniformity, transparency, and due diligence, government referred to all 6 packages under approval to re-evaluation committee for further scrutiny. Re-evaluation committee conducted comprehensive analysis considering prevailing market rate, input cost, practical feasibility of executing the contract at the quoted price. As part of this evaluation, respondent number 9 submitted a bid that was approximately 16% below the tender amount, making it the most competitive and viable bid as per the market rate discovered by re-evaluation committee. Based on its finding, the state government, after due diligence, accept the re-evaluation committee recommendation and issued the letter of intent to respondent number 9 Furthermore, the same evaluation criteria were uniformly applied across all 6 packages, thereby eliminating any question of malice, prejudice, or partisanship in the decision-making process. So, what I found after reading this, it is not a fact, but Mr. Tiwari has learned, my learned friend has projected. Other package consideration of 18/9/2023 was taken, but your case 18/9/2003 was not taken into account. He said that so far as all the packages which have a complaint was made, because there were some anomalies, they could not find out. So what they placed before, they said we have to form this evaluation committee, and re-evaluation committee has formed a subcommittee. Decision which was taken in respect of all the packages was uniformly applied. It is not a case that 18/9/2023 was considered in 3 package, and in my case 18/9/2023 was not applied. That was the stand of the government, my lord. I am reading, it is not my own stand, my lord. It is stand of the government which they have taken, which my learned friend has said, if I am not wrong, he said 18/9/2023 in 3 of the package, your package has not been considered. Am I clear to your lordship? This is a stand of the government. Now, if your lordship looks further, now in 272, page 272.
Yes.
See, my lord, 18 paragraph A, that as regard to subpara 22A, the constitution of the re-evaluation committee was necessitated. Now your lordship was asking that. Upon receiving complaint from bidders, particularly in the right of a writ petition filed by Mr. Rejoinder account before the Honorable Guwahati High Court concerning the rejection of bids under Rupa package, consequently, the Commission of Power Government of Arunachal Pradesh raised concern over the rejection of auto-generated L1 bidder based solely on justified bid ranges. It is clarified, re-evaluation committee did not introduce or apply any new condition. Instead, it strictly adhered to clause 36.2 and 36.3 of the standard bidding document of RDSS and para 7.57 of the Manual of Procurement Goods 2017 during its evaluation process. Hence, the petitioner claimed that re-evaluation committee changed the rule of the game midway is baseless and untrue. The evaluation process remained transparent, consistent, and in full compliance with the established guidelines. So this is the explanation which your lordship was asking, why a committee was placed in between, why this is the reason, my lord. They have not deviated, they are saying this committee. Now kindly see B, that as regards subpara 22B, the petitioner claimed that the issue regarding the question was RPD referred to a committee formed to other electrical division, and that this introduced hidden selection criteria. Lordship got it, man.
Yes, yes.
Is completely incorrect and misleading. The government of Arunachal Pradesh, by memorandum dated 29/5/2024, constituted re-evaluation committee to examine concerned rate regarding RDSS package across multiple electrical divisions, including Rupa, Itanagar, Nahalagar, Namsai, Deomali, and Pasighat. Thus, committee was formed to ensure uniformity, transparency, and procedural fairness in bid valuation, following multiple complaints from bidder and a writ petition before the Honorable Guwahati High Court concerning bid rejection of the Rupa packet. Upon reviewing the matter, the Commission of Power Government of Arunachal raised concern. Auto-generated L1 bidder has rejected solely based on justified bid ranges, necessitating a move detail evaluation. Consequently, for consistency in assessment, all 6 packages under government approval was referred to re-evaluation committee. Committee did not introduce any new or hidden criteria. In fact, instead it strictly adhered to clause 36.2, 36.3 of standard bidding document and para 7.57 of the Manual of Procurement of Goods 2017, ensuring that the only bids meeting technical feasibility and cost effectiveness were considered responsiveness. Further, petitioner asserted selection were rushed to favor respondent is completely baseless. Tendering process began on 17/1/2024. Due diligence was followed at every stage, including the formation of re-evaluation committee on 29/5/2024, submission on report on 5/7/2024, government approval on 8/1/2024, letter of intent 15/1/2025. after thorough evaluation and compliance with all legal and procedural norms. Now this is the stand which they have taken, and see practically they have stated about the memorandum of 18/9, 2020, a different paragraph they have mentioned of 18/9 at 276C, my lord. The as regards so and so, the government of Arunachal Pradesh memorandum dated 18/9/2000 was never part standard bidding. It was issued as a guideline to be considered while finalizing bid, but was not binding criteria for evaluation. The bid evaluation process remained governed strictly by the provision of standard bidding document of RDDSS, including clauses 36.2, 36.3, and so and so, so and so. Revolution, the re-evaluation committee addressed
18/9/24 was not.
18/9/2023 it will be. I think date is something
23.
wrong. 18/9/2023.
But the government stand is, these guidelines are not to be followed.
No, they said, my lord, not to be followed. It was a guideline only. What I understand, these are, my lord, these are not statutory enforced. Your lordship knows it. Now, suppose you have to look into the market rate survey, then all this was done under 36.1 and 36.2 and 36.3. They said we have not deviated with that standard bidding document. Because if you see, my lord, the judgment, a lot of judgments are there, unless it has to be spelled out by way of 309, where it is stated that yes, these guidelines will be statutory enforced. Here there is not statutory enforcement. Only it is a guideline. That is what I want to address before the court. That whether, number one, they say, my lord, government affidavit strictly said that yes, in one paragraph they said that it was issued as a guideline to be considered by, but was not a binding criteria of evaluation. But while deciding, my lord, I have read all the paragraphs, how they have decided. Re-evaluation committee, how a subcommittee was formed, and what was a consideration they have taken to account. Now, my lord, will kindly.
Just give us a minute.
Yes,
Just-
yes.
Yes.
So, my lord, why this 18/9/2023? This, my lord, there was a complaint from your lordship has seen from lot of bidders. There was a complaint which was made. And on the basis of that complaint, my lord, this everything 18/9/2023 also was placed forward before the re-evaluation committee, which was placed before the subcommittee. Now there is an order from the court, which I found that order. And that order says that yes, they will produce that report. On the basing on the court passed the order. Kindly see, my lord. If your lordship looks into the order of this court again, once again I am troubling. of 30th of September. I think, my lord, kindly look into that order. Once again, I'll just trouble your lordship with that order. Yes. It will know, yes. Now, my lord will kindly see there's order of the court on 39, 2024. Now, if your lordship looks into the third paragraph of 39,
Having considered,
that is already constituted committee consisting of 3 members with clear terms of reference with regard to issue involvement petition for passing a speaking order by recommending the acceptance or rejection of the bids. So this, my lord, so this is on 29th of May 2000. This committee was constituted on 29th of May 2024. 29th of May. Kindly note down, my dear, 29th of May 2024 and 15th of July 2024, detailed report was submitted. So now, my lord, will kindly see there is an order of the court. Consider the submission, consider status already considered committee, clear terms of reference with regard to issue for passing a speaking order by recommending the acceptance or rejection of the bill. So there is a clear cut because they produced before the court. They said that we have considered a committee and report is ready. And what we'll do, the court said you do it in accordance with report, pass an order accepting or rejecting it. So this what they have done uniformly they have applied in all the packages. They can't say that selectively it's only Pasigat, rest they have not done it. Your lordship has looked into it, the affidavit which they have filed. And I am asking myself, my lord, that whether there is an order from the court where a committee was constituted. It is a part of a judicial order. Today, what I have to tell your lordship that suppose let us say that your lordship finds that no, the number one, we can't accept the report. Let us say, for an example, let me put in this way. Subcommittee, in what manner they have constituted a subcommittee. Now, my lord, if your lordship decide that no, the subcommittee which they have constituted is not in accordance with the standard meeting document evaluation or in accordance with the memorandum of 18/9/2023. Now, what will happen now? Now, your lordship will only decide in respect of Pasigat because all other packages are not before this court. Other packages are not before this court, my lord. Only in respect of Pasigat. Now, my learned friends, if your lordship sees the prayer portion, what he made, he said, no, kindly see the prayer. He is only saying that so far as Pasigat is concerned, it should go. Kindly see that. See the prayer which he have made. Page 34. See page 34, my lord.
yes,
A writ in the nature of so and so should not be setting aside the recommendation made by sitting committee limited to NIT dated issued by Department of Power so and so for implementation of the project development of distribution infrastructure in ACI so and so. A writ in nature of mandama directed respondent made by the screening committee limited to NIT dated 17/1 so and so so and so. Next, a writ in the nature of such should not be issued setting aside questioning the letter of intent dated 15/1. Now, a writ in the nature direct to recall so and so issued to so and so. Now see at 36. A writ in the nature of mandamus should not be issued direct in response to settle the NIT issued by Department of Power for implementation of project so and so under revamp so and so in terms with recommendation dated 3/1/2025 issued by respondent number 4. And in alternatively, what he is asking, kindly see, my lord.
yes,
And in alternative, a writ of nature of mandamus should not be issued directly to the respondent author. Cancel the NIT dated 17/1/2024 issued by Department of so and so for implementation of project under so and so in standard so and so screening committee district. The prayer which is made. So now, my lord, when this committee's report in respect of all the packages, not in respect of Pasighat only. Now, if for a moment, let us say that your lordship interferes it. I'll put in this way. Your lordship interferes it and says that no, we'll interfere it. Because how they can form a subcommittee? They cannot form a subcommittee. Now, it will equally apply to all others, my lord, already, which is not because nobody has challenged it. Am I clear to your lordship, my lord? Now, what will happen, my lord? Once this order, my lord, I don't know what will be the outcome of the review. I am just hypothetical. I am putting a question myself. Then it will, it will affect the other bidders who are not before this court. Because what I find from the affidavit, uniformly they have applied. It is not a case where they have applied something different yardstick in respect of my case, my package and in respect of other cases. They said specifically we have, what we have done evaluation uniformly we have applied. Now the second argument which I like to advance before your lordship
Like
is that,
here, instance, you have raised this point.
yes,
Mr. Tiwari was emphasizing
yes,
that though the committee,
yes,
subcommittee had made.
For his benefit, I
Uh,
just repeat,
no,
my
no,
argument
no, no,
was,
no, no, no,
committee has found.
That's 356, if you come to
356 of the affidavit.
his specific argument which we have recorded,
And
Yes.
page 247 of it.
356.
356.
Yes.
Is that so far as the Rupa
Rupa
package
and-
is concerned,
I have seen that.
one joint account was found L1, instead the LOI was still given to TNT.
My lord,
In spite of the committee's
my lord,
recommendation. That is the
this
argument.
is his argument.
Yes.
But I don't know on what basis he made this argument.
Page
No,
257,
no,
that is the basis.
Just a minute. Mr. Tiwari did not make this argument on omnibus basis. He has said that 3, I do not have the instructions for 2. 3, I have the instructions. Because we have asked about the next 2 also. So far as Rupa, Itanagar and
Naharlagun
is concerned, he has very clearly said that in spite of the committee declaring somebody to be L1, yet the LOI was given to somebody else. He has said that I do not have instructions for as Namsai and Deomal is concerned.
Right.
Sikhat, we are considering this is subject matter of dispute.
And to clarify this further, it is supported by page 247 of the writ petition. Page 247 is a part of the subcommittee's report. In page 247, committee specifically says, in respect of Rupa, Itanagar and Naharlagun, that the rates of L1, they are workable rates. So, my lord, if the rates are workable, why did you not give it to L1?
My lord,
You gave it to others.
I'll just give an answer. So far
Okay,
as
we'll come back to
two package Rupa and Rupa package and Itanagar. Please look into 354. 354 of the affidavit of the government.
Yes.
See this, that is the summary of findings. See,
Yes, yes.
see discrepancy. Upon detailed scrutiny of justification provided bidder to the superintendent engineer come chairman of tender opening and evaluation committee response to the inquiry under clause 36.2 of the standard bidding document, copy of justification available. Significant deviation were identified between the item-wise market rate derived by the committee and item-wise breakdown cost justified by bidder except for Rupa and Deomali. Logic Gaurav. Rupa and Deomali claiming to be the manufacturer. A detailed analysis comparing the item-wise justified rate provided by bidders and rate committee through a market survey is available in the Excel sheet item-wise rate analysis market annexes for perusal. In this regard, it is pertinent to mention that even the bidders who have provided item-wise justified rate have not indicated the overhead expenses, contractors' profit, transportation charges, freight, insurance separately. Hence, the committee considered the cumulative price quoted in the bids by the bidder for determining the capability of bidder rather than on the basis of item-wise justified rate submitted. Now, my lord will kindly see now the 358, kindly 358. This is a recommendation. Kindly. Now, after a thorough They can only recommend, my lord. They can't say that you settle with that.
Yes,
Here, see the recommendation. After a thorough re-examination justification provided by bidder and detailed market analysis, subcommittee found significant difference between the market rate discovered through the market survey and the price quoted by bidders. The finding indicate a bidder quoted higher than the approximate lending rate determined by the subcommittee. Therefore, regardless of the ranking as L1, L2, L3 or L4 in the auto-generated price schedule, bidders appears to have the capability to perform the contract as the price quoted by them in relation to subject matter of the contract, scope, delivery schedule, allocation of risk. However, it should be noted, NAMSAI package, message so and so as quoted minus 3.8% below the approximate lending rate determined by subcommittee, raising concern about the ability of contractors requirement. So now this was placed before the government. Government has looked to the report of the rehabilitation committee, which they again form a subcommittee, and they have taken a decision. Yes, he can do it because on the market rate which they have evaluated, and accordingly letter of intent was issued to me. That's the case, my lord. Now, my lord, the one question again will arise, which I said that already there is a part of the court's order. Now there are other contractors with humble submission, is a humble submission before this court. It will, my lord, the others bidders also, if any comment is made on this package, my lord, others also will have a ramification on it. That's my one way of putting it before this honorable court. Second, my lord, now there is a decision which has been taken by the committee. Now, to what extent your lordship will enter into the decision which has been taken by a committee? A detailed analysis, evaluation has been taken. Now, to that extent, there is one judgment passed by your lordship. And to that, whether that can be, your lordship can sit over a judgment passed by an authority who decides, because they are the best person who knows technical, financial, legal. Kindly see more judgment. This is a tender of a road is regard of the same justified rate. And a committee, in that only difference is that there was an OM. OM attached to the bid. OM attached to the bid, which your lordship will now find at paragraph 47. Para 47.
yes.
Let us now deal with the submission alias violation in process of working out justified rate. It has been argued that a committee constituted by OM dated so and so to work out justified rate does not match with the signatures of the members appearing in the worksheet to come to justified rate. A careful exam of worksheet would reveal that the signatories of the chief engineer, so and so who is the ex-officer executive engineer, are present along with that of assistant surveyor of works. The only signatory who is not emphasized by the said notification that of the assistant surveyor of work. Learned senior additional explained assistant surveyor of work was having the ground knowledge of the work in question, had only assisted the committee and is present, would not vitiate the proceeding. Principal object working a justified rate as per OM has been duly. This court is inclined to accept the aforesaid submission behalf of the state on two counts. Firstly, rate which has been worked out is a committee having specialized knowledge and the finding arrived, and this court cannot sit on appeal over the finding arrived at such committee. Secondly, in absence of allegation of malafide or lack of transparency in the decision-making process, any interference by this court in regard would be wholly unwarranted. My lord, the facts may be all different because that's an OM. There was a signature of one of these particular was absent. But they said, how can you rely on that? Ultimately, the whole principle of this case is that this committee who is having a special knowledge and finding, whether your lordship can sit over an appeal over the finding arrived by this committee. So this is my humble submission before this honorable court. I think rightly they have decided and they have not deviated unless your lordship has to look into record, because your lordship wanted to see the record, how this committee was formed, in what manner it has formed. But what But what it has been spelled out now in the affidavit, my lord, it is clear now in the affidavit. I was thinking that why there is so gap from April to November, they were sitting idle, nothing has happened. This is what has happened in between. Intergram, this has happened. Make a lot of bidders were waiting, as my learned friend said, they were waiting. Well, this is the decision. It is not happened that what it was projected as if, my lord, I was rejected, my bid was rejected. Thereafter, my lord, without considering it was given to me. Without considering it was given to me. This was placed before the committee. Maybe later stage it was placed, but before taking a decision, because this bid found valid and was sent on 3/1/2025. 3/1/2025. And all this happened prior to that. I could have very well understood, my lord, my rejection was passed and thereafter this committee was set. The committee was formed. It is not that only favoring or selecting me, this committee was formed. This committee was formed earlier to that and in respect of all the package. It is not a case where they projected selectively they have done only to favor the. So this is what my humble submission is this, my lord. The petition doesn't have a merit in this case and your lordship should reject this particular district petition. And if necessary, I can place that. Let's see, my lord, what my learned friend or my learned colleague gives a reply to it, my lord. Yes.
Yes, any,
Not short reply. The first argument is that the explanation of respondent 9 was sound, it was logical, because the explanation they had given justifying their rate, that it is not abnormally low. The justification was given in the dated 15th of March 2024. It has been argued that the justification which they gave was absolutely sound and logical. Be that as it may be sound, it may be logical for them, but my lord, this was not found logical, this was not found sound, and my lord, it was found not workable, and decision was communicated to them by letter dated 22nd of March 2024. Now, my lord, the question I'm asking myself is 22nd March 2024. They were communicated with the decision that their rate is abnormally low and they are not satisfied with the explanation given. Now, my lord, the question.
You're referring to 211.
My lord, I'm referring to
211.
211, yes. Yes. So, my lord, the question I'm asking myself is, that means, my lord, it is the communication of the government dated 22nd March 2024, which gave them a short shrift. If that be the case, they could have come before the Honorable Court and said that, well, the communication is not legally tenable, it is perverse, not based on materials, arbitrary, non-application of mind. That is not the case. They kept quiet. For some good reason, they had a belief and faith that some committee will be formed sometime in future and will act to their advantage. I presume that. Now, the second...
You're restricting to having belief and faith, not having an overt role in constituting.
They never came before the Honorable Court.
Not having an overt role in constituting the committee.
Possibly, my lord, I don't know.
You are entitled to say that. We may not be entitled.
There was something in their mind. There was something in their mind. Possibly they knew.
Believe and faith.
Yes. Possibly they believed that there would be subcommittee. A subcommittee will decide in their favor. Now, my lord, the committee is finally formed on 29th of May 2024. Why was it formed? It has fallen from my esteemed and from the government. There was a complaint in connection with Rupa package. Rupa they specifically named. They are silent about all other packages. Only Rupa has been named. Why should I presume that there was a complaint in respect for Pasighat when Pasighat has not been named? Not only Pasighat has not been named, Pasighat figured subsequently in June 2024. It was never there in the 5 packages. They brought in Pasighat. And therein I say, I bring in Jagdish Mandal principle. Pasighat was brought as an afterthought, much later, after the formation of the committee. Now, my lord.
But they wanted to invoke the yardstick uniformly.
I'll come to that also. Then comes, my lord, the third argument.
And he is also emphasizing
uniformity.
that the subcommittee is also kind of endorsed by orders of the court.
My lord, I'll answer this.
That is what he's trying to hint
My
upon.
lord, I'll answer this. Now, the third argument, my lord, is there is uniformity so far as the action of the government is concerned in acting upon the recommendation of the subcommittee. This is what I have understood. If there is uniformity, then I ask myself, where is the uniformity? The finest so-called non-existent uniformity is page 355 of the government's affidavit in opposition. Page 355 of the government's affidavit in opposition, which is a replication of page 247 of the writ petition. The subcommittee report itself. The test of pudding is in eating. Page, my lord, 355 of the affidavit in opposition of the government, which is in fact page 247 of the writ petition. It is part of the report of the subcommittee.
Yes.
Now, page 355 is very legible, very clear. That is why I am referring to it. Otherwise, it is page 247 of the writ petition.
Yes.
Part of the subcommittee's report.
Yes.
Lordship may have a look at it. I read from page 355 of the affidavit in opposition. A summary of the comparative analysis highlighting significant discrepancies between the market rates discovered through market survey and the bidder quoted price is documented below package wise. Rupa, the rates discovered through the market survey amount to rupees 22.18 crore, while the price quoted by the lowest bidder, that is L1 in Rupa, is rupees 25.76 crore, which is 16.13% above the market survey. That means it is workable. But my lord, have you given it to L1? We have shown. They did not give it to L1. Page 450. They have not.
No, it is not workable. 16.13 above.
My lord, the rates discovered through the market survey amounts to rupees 22.18 crore, while the price quoted by the lowest bidder is rupees 25.76 crore, which is 16.13% above the survey rate. That is why, my lord, it is not abnormally low. It is not abnormally low. Because ultimately, my lord, the lowest bidder was L1.
The stipulation cut across both the low side and the higher side.
Yes.
It cannot be high above a specific level, cannot be low after a specific.
But my lord, they gave it to a party whose rate was higher than the lowest bidder. If the lowest bidder's rate was only
lowest bidder in terms of their everything, it was Conte was signed with other people. But offer was given to the lowest bidder. On this denial only by us. The given situation. That's why I say.
You have stated in the affidavit. You have stated in your affidavit.
No, this come in the reply. Let me have it.
then Naharlagun and Itanagar.
Not say such situation given situation. We are not following this committee. We have followed a committee. But in the like requirement, anyone offer the work, but he declined to take the
That's, my lord, there is great degree of ambiguity because they say in a given situation, So there is always that free play in the joints. Very peculiar. We don't know where do we go. Either you strictly act upon the recommendation of subcommittee or you don't. Fact of what we find is, in fact, the L1 in Rupa, Itanagar and Naharlagun were not given. It is, I think, the L2 or L3 as per the justification. This is what we find. So page 415 is there, letter of intent. Letter of intent now, which is letter of acceptance. So, my lord, how do we test of pudding is in eating it? What we find, their actions on the paper. As to what is behind the action is very, very difficult to decipher. So, this is one part of my argument. So, uniformity, prima facie is not there. Uniformity, they say it is uniform, but it is not translated into action. We don't see an evidence of uniformity, is my submission on paper. Then, my lord, the further argument is 18.923 is only a guiding principle. I am on guiding principle now. If it is a guiding principle, in a pre-bid meeting, you tell everybody, this is the 18.923 memorandum. Our action would be in conformity with the 18.923 memorandum. So, my lord, if I am a bidder, I have in my mind the justified rate, that there is a range. And
when was the pre-bid meeting?
Pre-bid meeting date is, my lord, the date of the pre-bid meeting is 25th January. Page is page 187, 188 of the writ petition. 187. All were present. All the three bidders. Three means all seven bidders. All seven. 187, 188. So, my lord, dicta of the Supreme Court is to the contrary. You are government, you are a state. You say this is the standard by which I will be guided. And you do not act in terms of that very standard.
Yes.
So, my lord, 18.923 is not a mere guiding principle. I would put it this way, it was a yardstick and the scale and the standard by which state government professed its action to be judged. So, you will be judged by that very action of yours. Nothing more, nothing less. Now, my lord, the further argument in the writ petition, the prayer is for Pasighat. Our concern is Pasighat. We are not concerned with the others. We are not concerned with Itanagar, Naharlagun or Rupa. I do not understand. In Pasighat, if there is unfair play, prima facie we can demonstrate how that will affect the others. Others are not before the Honorable Court. It's a judgment in personam, not in rem. I am not in a PIL before the Honorable Court. I am for enforcement of my rights and I am seeking redressal of my grievance. Techno power is not before the Honorable Court. I see a ray of hope and I say, please, guided by 18.923 and take an action in accordance with that. That is all, my lord, my submission. That's all. If there is a doubt, I'll try to clarify that. Oh, yeah, my lord, my learned friend will clarify what happened in Jain Count. He was a lawyer. I don't.
Not necessary.
There is something because since his name appeared.
Where? In which matter?
The joint account matter
Yes.
was referred to. The argument was, in that particular matter, there was a judicial observation regarding this committee. I was there in that matter. I retained the matter. Our entire case was that since our bid was rejected at that point of time, we came before this honorable court in the month of March. When the matter was taken up, there was no orders passed by this court for any committee. Just notice was issued. Then one day when the matter was taken up, there was an argument, there was a submission from the other side, from the government side, saying that we have constituted a committee. On 2nd of May, the writ petition will also takes up the notes down the number also. Writ petition 179 of 2024, the joint account case of Rupa Benz,
Yes.
which was referred to.
Yes.
Now, the first day the matter came up on 2nd of May, 2024. The matter came up for motion on 2nd of May, 2024. Notice was issued. There was no stay order. There was no observation as such, only notice was issued. Returnal after 4 weeks. I think. On 2nd of May, 2020.
No, no, it's not second, it's 3rd of May.
Sorry, 3rd of May.
First order is 3rd of May.
Yes, 2nd of May it was filed. I said that. 2nd of May it was filed. 3rd of May it was taken up and notice was issued.
Okay.
Therein, when the matter came up on a later stage, I do not remember the exact date when the matter came up.
No, Mr. Das has he's taken out the orders. He has placed on record. Next came before all the.
Adjudicate on the merits of this committee. And a submission was made that the government has made a committee to look into this matter. Therefore, the Honorable Court has simply said that if you have made a committee, whatever report is there, produce it.
But this submission had come from you on 39.
Yes.
Mr. Sharma, the learned counsel, by placing a copy of the memorandum dated so-and-so, issued on 29/5/2024, has submitted that the state authorities has referred the matter to by constituting a 3-member committee to examine the issues involved in the writ petition. However, there is no speaking order.
When
And the
is-
matter
when
is
the
in
date of that order was
39.
39. In fact,
39.
probably there were other orders prior to this, when there was this submission made from the government side that the matter is placed before a committee. Thereafter, the instruction from my client and got this memorandum at that point of time.
On 25, it was supposed to be listed, we do not know. 25 was the date fixed, but do not have the orders of 25.
But remember that.
But you say that this constitution of the committee was not by the court, but by the government.
The Honorable Court was never called upon to actually on a measure the committee. Neither this Honorable Court had passed any orders directing constitution of this commission. And if there is any issue of conflict of interest, if I may also submit, I am only assisting my senior here, not in this matter.
I didn't say anything.
No, I'm just adding.
No, there is
I'm
not
just adding
any.
to it. Because there was a submission made that in one package, we are relying on that, and here we are objecting to that. So on that aspect, if I may submit.
No, what?
If there's the issue of conflict of interest, I
No.
find
There is no question of any conflict of interest. I pointed out because 18/9/2023, he has sought for setting aside that memorandum. And today, in this case, they are relying on 18/9. That's what I am pointing out.
Equating both the cases
Yes,
together
you can't.
is giving a reference as to if there is some conflict of interest. It is not. It is a loophole mechanism of their practice. And I'm not in this matter. No, I'm just clarifying. This package was never called upon for adjudication on merit. I mean, this constitution. This is the first case which has come. That will be my clarification on that, Rejoinder.
Yes. Okay.
Please forward the 17 and please 417, 426.
LOI has been translated into LOA now in respect of Rupa, Narda, Kun and Itara.
The aspect of justified rate or viability factor, which was the subject matter of Datta Associates.
Yes.
Here, 18/9/2023 has taken into consideration. Unlike the Datta Associates, where there was no introduction of anything called viability rate, so therefore there was the interference. Here, they have said that yes, justified rate would be one of the factors. If
Yes.
it is abnormally high or abnormally low, we would go for justified rates.
Yes.
And the second
And this is
clause,
supported by clause 36 and advanced.
second clause, validity of the justified bid ranges, justified bid price ranges provided herein shall be valid for the bids quoted and award of the current year of 2023-2024, in which this particular Pasighat falls under category 1.
My lord, and the difficulty arises, the 18923 memorandum gives the entire list and ranges of prices. Now, the entire list and the ranges of prices was subverted by a subcommittee by carrying out a market survey in Calcutta. So practically, my lord, it's a go by.
Low or excessively high and obstructive biddings, justified range of bid prices of matter. Adopted. Okay.
My lord, I'm putting it this way. The justification price range laid down in 18923 memorandum was not only subverted, given a go by, but it got transformed altogether into a new justified rate by holding a survey in Calcutta on the basis of the vendors list of REC. Practically, my lord, it is a new 18923 memorandum which was created by the subcommittee. This is what it is. This is the practical implication of that. One was erased and another thing was brought in. Could that be done? Is a simple question. They could not have done it, my lord. It is practically changing the entire rule, the whole thing, when the process was over. That is my submission.
Okay. Yes, we'll close this. Or 3 PK, you are a learned senior counsel. Who is assisting you? We cannot write the name of Mr. Sharma now. All along we thought that
because of traffic jam, my lord, even he was also not there. So there was none with me and I was all at sea, then he came.
And I know the background of this.
But how does he know all the facts?
Yeah, he knows all the facts.
All the pages and the paragraphs. Instantly he learned all the facts. Okay, doesn't matter. Lighter vein. All is permitted in love and war and in cases. Everything is fair. So PK assisted by
El Sangam.
Ang Santama for the petitioner. Also had 3. L permit, the Learned Standing Council Power Department. 3. D Das Learned Senior Council assisted by
Vicky,
the Pangi has appeared for the response number 9. Are you handing over any records? You hand over the records tomorrow. Okay. Then before him, 3 permit, the Learned Standing Council is directed to hand over the original records by tomorrow. Only Pasighat decision. Subcommittee, yes. How was it formed? Everything. That part. Mainly on the formation of the subcommittee. Okay. Because you are emphasizing on public interest. Would like to have that in record. Okay. Hearing is concluded. Judgment is reserved.
lot of lawyers are waiting. I feel very embarrassing. I don't know how to tell your lordship that is one matter. Item number 30, last time I came and request was made that if possible, I'll try to upgrade, but there are a lot of lawyers who are sitting behind back. So can I just pray? If today I'm here waiting for the turn, I'll wait for that, there is no problem. Or even then it can be continued for tomorrow also, my lord. I'll be online, no problem.
Let us see the other matters.
Yes, ma'am. I'm here, my lord, no problem.
Yes.
Lordship,
Item number?
18. I'm for respondent.
You cannot mention a matter at this hour. How do you, we are in the midst of the proceedings. Mention when a turn comes. Yes, next.
Maybe
Yes,
the
Mr. Rama.
Lordship, here the petitioner is working as a assistant director in the savings. So initially, he was appointed in the year 1995 as LDC. Thereafter, in the year 2002, he was promoted to the post of UDC, and then in 2008, he was promoted to the post of accountant. After he was promoted to the post of accountant, he became eligible for assistant director after completion of 5 years of service. But before completion of that period, he was given the promotion to officiating promotion with the scale of pay of the accountant in the year 2012, April 2012. Thereafter, in the month of October 2013, he completed the period of qualifying, and thereafter he submitted a representation to promote him to the post of assistant director by holding DPC.
Yes.
But since then, till today, he has not been given the promotion, nor he has been given the salary of a assistant director. So this is my
salary of assistant
director, Lordship. He is
But
still
you
now
have
he
not
is
been promoted. How do you get?
yes,
the-
yes, Lordship. My prayer is that he should be promoted by holding DPC and give him the financial.
Yes, madam. Will issue notice at this stage.
Lordship,
You take instructions.
Lordship.
Heard Sri R. Sharma, learned counsel for the petitioner, whose grievance is with regard to non-holding of a DPC for a considerable length of time, by which he has been deprived from the avenue of being promoted to the post of assistant director.
Yes.
From the present post. Assistant director, full stop. It is the case of the petitioner that though he was substantially holding the post, though he was promoted to the post of UDC in the year 2002, he was allowed to officiate as an accountant in the year 2008. And by virtue of the Assistant Director, Small Savings Recruitment Rules 1999, claims to be eligible for his next promotion on 31/10/2013. He has also claimed that he has been allowed to officiate as an assistant director in the department. However, with the scale of pay of an accountant. Let notice be issued. Returnable by 4 weeks. Ms. Basar, the learned state council accepts notice on behalf of all the respondents.
Let
Extra copies be served upon her by tomorrow. We give a date. Returnable date. Yes, please suggest a date.
Yes, sir.
The returnable date is fixed on 20th of June. 20 June, Friday. Okay, Mr. Sharma?
28.
20.
Yes. Right.
Please tell it. Item 10. Yes, Mr. Kato.
My lord, this is a small matter, my lord. My lord, on flimsy ground, my lord, my NIT has been, my lord, the NIT has been rejected, my lord. My bid has been rejected.
Your bid has been rejected.
My lord.
You had participated in an NIT.
Yes, my lord.
Of 21/12/2022.
Yes, my lord.
Mr. You have filed your affidavit.
Affidavit, my lord.
Yes. What is your stand?
So therefore, my lord.
Ratings are over.
My lord, private
My
response.
lord, his bid was never rejected, but not considered, my lord. Rejection and
Who
consideration
is the
different.
private respondent?
Private respondent, my lord, he is the beneficiary, my lord.
Where is he? Who is he?
He is respondent number 4.
No, no,
We
who is
have taken-
appearing?
My lord, we have taken steps, and to that effect, my lord, additional affidavit has been filed. He refused.
Dusty.
Yeah, Dusty service has been, my lord, given to him. He refused to, my lord, accept a copy. To that effect, my lord, was also filed, my lord.
Okay, that has been taken into consideration
Yes.
by this court.
Yes, ma'am. If additional affidavit dated, my lord, it was filed. Now, service in respect of.
Which order the service was held to be complete?
The steps taken placed after 3 weeks. It is 1/8/2024, my lord. 1/8/2024.
It stated at the bar that yes, can we take it up for disposal, Mr. Nabam?
My lord, yes.
How long will it take?
My lord, it will not take much time, my lord, only,
No, I find the number of councils, learned council waiting for their matters. If it is not very urgent, then we'll not have a hearing disposal matter today. Because the other matter had taken a lot of
in
time.
that case, my lord, may I pray that, tomorrow, if lordship will accommodate, or day after tomorrow, my lord.
Day after, it may be possible.
My lord. Day after.
Day after, okay. On a request made by the learned council for the parties, list this matter for admission hearing
My lord.
on Thursday. Please give the date, huh?
My lord. Deep level.
22nd, huh?
Yes. Much.
14 and 15, Mr. Patil.
My lord, here in the case, there are 9 respondents. Who? 9 respondents.
9 respondents are
Nine
there.
respondents.
Okay.
And none of the respondents has filed any affidavit. And instead of filing any affidavit, they raise always issues. So,
Why affidavit not filed?
yes. Whatever.
Would you
written
like to
there
file or
is-
not? Are you foreclosing your right to file affidavit?
Yes.
My lord, by order dated 6/5/2025.
Please use the microphone.
By order dated 6/5/2025.
Yes.
There is an order pursuant to order dated 28/4/2025 passed in first earlier in this proceeding, Mr. R.H. Nabam, learned additional advocate general, Arunachal Pradesh, obtained the relevant instructions and submitted that the petitioner of WPC number 1111/2025 had withdrawn the earnest money deposited with his tender involved in this proceedings. So, my lord, the first writ petition which the petitioners have filed, at that point of time, there was no interim order. But suppressing this particular material fact, this writ petition was filed. Second one, yes, ma'am.
111 of 25.
111 of 20.
Initially 95 of 25 was filed.
No
interim order.
No interim order was there.
Same relief has been claimed in the second one.
Relief was given in the second one.
No, same relief has been claimed in the second.
Claimed in the same one. Because,
Same relief.
Yes, my lord, because that work order
Yes.
was awarded and that was not part of the challenge.
Okay.
And therefore, my lord, that this is that. And in the meantime, my lord, why I have not filed the affidavit is, it is the government action. It is the government council who has to defend their action. Because even if the order is good or bad, my lord, I am a beneficiary of that bad or
No,
good
will
order.
will you file or not? We are not on the justification. Will you like to file affidavit? Or-
Yes, let him,
No, will you like to file?
I'll file.
Mr. Nabam, is it a fact that in the second subsequent writ petition 111, in the subsequent writ petition 111 of 2025, in the pleadings, there is no mention about the earlier writ petition?
My lord.
Is it a fact?
My lord, I have to re-verify that. I doubt, my
Mr.
lord.
Patil,
But
in the subsequent writ
just a
petition,
minute, just a.
have you made a mention about the earlier writ petition?
Yes,
Then
I mentioned. That
it
it
is a
is
wrong submission then.
no, WPC number 95.
Fact is,
By
withdrawing the
EMD.
they have filed this petition. That was my submission.
my
My
lord,
lord,
that in the case, I'm always,
My lord,
my submission is that they raise issues and issues, but they never file affidavit.
Okay,
So-
we have last
so-
opportunity to file, but the matters are of 2025, not very old
my
matter.
lord, as per the instruction, my lord, as per the directive of the court, my lord.
Yeah.
My lord, instruction are short from the department.
Let all
Whether,
the
my lord, the
respondents-
petitioner withdrew the EMD or not, my lord. Affirmative, my lord, the answer was right, my lord. Then the allegation made by the, my lord, petitioner, the private respondent have not submitted EMD. That is also correct, my lord.
No.
Yes,
No.
that is okay, correct.
No, no.
Yes.
Then you file the affidavit, but that is the, no. Why are you?
No, no, no.
No, right or wrong, you have to stand yourself. You can't depend the government.
No, if an
You
allegation
cannot
has
insist
been
the government
made,
that he should
Mr.
file.
Tara, by the petitioner, that you have also not filed your EMD, you stated on affidavit that you have
Correct,
filed.
Mala, then,
Yes.
why Mala he is not filing the affidavit, Mala? You file it.
The direct
We'll also
order
file the
remains-
affidavit. Mala.
Tomorrow, Mr. Tara will have to come to this side. Both of you fighting against the government together.
Mala,
No,
I'm forcing such a situation.
direct all the respondents to file affidavit
Yes.
in the form of affidavit.
Yes, 2 weeks, we'll fix the date.
And in the meantime, the
Heard 3M party
interim will
learned
be enforced.
senior counsel for the petitioners. Assisted by Sri. Also heard Sri R.H. Namam, learned AAG for the state, whereas Sri T.T. Tara, learned counsel is present for the respondent number
7 in 95. I will file.
for the private respondents.
7.
Private
Private
respondents.
respondents.
It however appears
what is new?
that in these two writ petitions, the affidavit in opposition,
6, sorry, I'm 6.
that's private, affidavit in opposition, affidavits in opposition, affidavits may as you know, have not been filed, are yet to be filed by the respondents, para. Considering the subject matter in dispute, 2 weeks further time is granted both to the state as well as the private respondents.
And
Respondent
interim,
to file the affidavit.
interim,
Let affidavit be filed. No, let this matter be listed on, if we give a date, today is 28, 20.
Today is 20, my lord.
We'll have it on 6th of, you get more than 2 weeks.
Very well.
6th of June, 2025, by which time the affidavits are to be filed invariably. Para, interim order passed earlier to continue till the next date of listing.
My lord, I will file affidavit in opposition only in respect of WP 95.
Wherever.
I don't know, my lord. Either one or.
Yes, yes.
In this case, today is a returnable date also.
Okay, notice was issued.
Notice issued, already served to them. But they have not
Notice
filed
was
any
issued
affidavit.
on
Need some more time.
11/4. From 2022, we have not taken up any exercise for filling up the post by promotion. Have you got the instructions or
No,
not?
your lordship. Need some
Get the
more time to file
instructions.
affidavit.
11/4 was the date. We are, more than a month has passed.
Yes.
Okay. Heard Sri R. Sharma, learned counsel for the petitioners, para. No, para, notice submits that notice was issued on 11/4/2025, whereafter extra copies of the petition were served on the learned state council, para. Ms. Basar, the learned state counsel, however, prays for and is granted 3 weeks further time to file the affidavit in opposition. List after 3 weeks.
So maybe it's on 20 June, maybe fixed,
As requested, list on?
20 June, 20.
Yes, we can do 20, then make 4 weeks, huh? 4 weeks, list on 20 June.
Obliged.
So it can be 3 weeks also, no problem. 3 weeks, then 20 June. Item number?
Lord, I appear for the respondent. For petitioner.
My lord, the epidemic has already filed. Today is for admission hearing, my lord. Now I am ready for the admission hearing, my lord. My lord,
Then I argue on maintainability first.
You're raising the maintainability. Then we'll hear on the maintainability issue. Are you prepared on the maintainability issue?
yes, my lord, I have.
What is on what ground?
The issue is.
No,
it
on
is-
what ground maintainability?
Well, that's why I'm explaining the facts very briefly. The issue is, my lord, election of the chairperson of Jila Parishad. The writ petition was, when the writ petition was filed, at that time, election process was complete and the respondent was declared elected as chairperson of Jila Parishad, notification was issued. But in the writ petition, the argument was that they have not gone to the tribunal.
AEP.
They have not gone to the tribunal because what they are challenging is the very initiation of the process of election. The very initiation, the argument was, is that ipso facto illegal, ab initio void. So if it is held to be ab initio void, the very initiation of the process, then the entire everything will fall and even the election will have to be declared null and void. This was the argument. Now, my lord, the argument was based on a premise on the literal reading of Rule 67 of the conduct of election rules under the Arunachal Pradesh Panchayat Raj. Now, Rule 67, my lord, gives powers to the Deputy Commissioner. Deputy Commissioner is supposed to do 3 things under Rule 67. Number 1, issue notice of meeting for Jila Parishad members. Number 1. Number 2, fixing a date and venue for the meeting. And number 3, appointing the presiding officer for the meeting who would conduct the meeting, and the presiding officer is supposed to do many other things thereafter. So these 3 principles the commissioner is supposed to do. What the deputy commissioner did in this case was, deputy commissioner appointed additional deputy commissioner to preside over the meeting, and rest of the functions were delegated to him to fix the venue of the meeting, to fix the date of the meeting. So this is the principal argument. Now, my lord, I am going to demonstrate, so far as maintainability issue is concerned, that power under Article 226 can be exercised only to facilitate the election, not the process of election or to stop the election. In any case, even under the Mohinder Singh Gill case, etc., my lord, all those passages are there, because the issue came into consideration, my lord, before the division bench of the Patna High Court. All these cases were referred. The issue was regarding the panchayat only. Perimeter provisions are there. So in that very particular judgment, my lord, all these series of Supreme Court judgments have been referred and explained. And it has been held that only for the purpose of subverting or stopping the election, power can't be exercised. It is only for the purpose of facilitating the election. And if the election is there, you don't have a choice, but you have to go to tribunal. This is the principle.
So where will his remedy lie? If he is alleging, may not be a case specific and a very subjective term, one may be aggrieved by a process initiated for holding an election. Can he be remediless? It is not a question of 329B. There were an absolute bar is that once it's initiated, it's only the remedy election petition.
But my lord, the expression
We do not know what is there in 67.
Article 243, I'll just place the constitution.
No, we do not know what is there in 67, which you had referred. Is it a perimeter provision of 329B of the article?
My lord, then I will refer to Article 243 of the Constitution
regarding the
panchayat and all.
Panchayat, yes.
In Article 243, my lord, the expression is comes under, yes, Article 243, capital O.
Yes. We are,
Bar to interference by courts in electoral matters.
yes.
very similar to Article 329.
B.
Notwithstanding anything in this constitution, not,
Yes.
it's a non-obstant clause.
Yes.
The validity of any law relating to delimitation, Lordship may skip that. B,
Yes.
no election to any panchayat.
Hmm.
Now, my lord, panchayat has also been explained, meaning be it district panchayat, Jila Parishad, or Gram Samiti. Any panchayat has been explained in the definition clause.
Yes.
No election to any panchayat shall be called in question except by an election petition presented to such authority and in such manner as is provided for by under any law made by the legislature of a state.
If you come to 329B,
yes,
the expressions are almost perimeter.
Yes, number one. Number two, below the Supreme Court itself had an occasion.
The question which will come from this court, that in an election petition, if we remit him to filing an EP, will he be in a position to take up this issue of the process being initiated not by the appropriate authority but by his delegate? I think that is the issue he's trying to raise.
This is the issue. But I can this issue merit also.
No. Whether he would be in a position or whether he will be in a legal foundation to have it adjudicated in an EP.
Because the expression is very wide. Any election, no election to any panchayat. Even if you initiate the process, it itself is the part of election.
Tribunal would say that we can only decide the validity of the election, not of the process initiated.
Either
we
way,
do not know because he cannot. No citizen can be left remediless. That is also an 226.
Because there are 3 to 4 judgments of the Supreme Court dealing with the panchayat itself, dealing with Article 243 capital O. I'll place those judgments also, including the Patna High Court judgment, wherein those judgments were also.
Yes, Mr. Bui, what is your initial reaction to 243 O read which to the 329B of the Constitution of India?
Yes, my lord, the learned council, the senior council has summarized that maintainability of the petitions. My lord, that regarding of that, your election tribunals of the panchayat, election tribunals of the panchayat, any dispute, any rejection of the nomination paper, or any at the time of the general panchayat elections. But my lord, here is after election has been completed. Only for my challenging is that proceeding of the Jila Parishad member among the elected Jila Parishad members.
You are not challenging the election.
My lord, this is a district bifurcated from the lower Subansiri district to Key Pioneer district, my lord.
The subject matter of your challenge,
Yes.
is it pertaining to an election or is it not pertaining to an election?
No, my lord, I am not challenging of the elections. That I am challenging for the process of system of the become elected of the Jila Parishad chairpersons within the Jila Parishad chairperson, my lord. I am not the
How is the chairperson elected directly by the people or
Elected by the members.
elected by
would it come under the definition of election?
Yes, it does. I'll show that.
Or it will come under the even that can be challenged in an EP. Okay.
That my lord only for I am
Even tomorrow I'm available, so I have no difficulty. If he may continue or let him argue on merit, I will answer everything, both maintainability as well as merit. Either way, whatever way my lord feels.
Let us see the relief which he is seeking. What are your prayers, Mr. Bui?
my lord, here is that
Prayers. Page.
My lord, my prayer is very simple. And serious matters, the eyes does quest the notifications of the.
Let us see the prayer at page 14. Watching the notification, election notification.
My lord, please see the annexures. Annexures C of the page 30, my lord.
Page?
Page 30, my lord.
30.
Yeah, 30, my lord. 30, my lord.
When was the elections held?
My lord, it was held on
March.
1st April 2025.
What is the term?
Yeah, tenure is 5 years, my lord. Yes, my lord, please say that this notifications or the issue by the member secretaries, my lord. My lord, this is the
Yes, please read 28 March 2025.
25, my lord. The Panchayat,
2nd April was the election, 2nd April.
Okay.
my lord, that the, my lord, the Panchayat Raj Conduct Rule Act, the rules 2021 in the returning officers of the key Panchayat Jilla Parishad constituency, the conduct elections of.
What about your grounds of challenge?
My lord, this is my ground of the challenge is that, my lord, here without any very short notice, my lord, without the sharp opportunity made, during the period of the holidays, election notifications comes. I am a Jilla Parishad member of the Bharatiya Janata Parties. I am not any communicated from that returning officers, my lord.
What is the tenure which is required to be given?
The,
Minimum tenure, as per which rule? What is the tenure?
yes, my minimum tenure is 5 years. Now,
No, not tenure. What is the period which is required for issuing notice for
yes,
holding the
sir,
election?
at least the start was 7 days.
Where
Yes.
is the rule? Which rule?
My lord, please see the conduct rules. AP code, Arunachal Pradesh Panchayat Raj Minerals.
This one, Mr. Bui?
Yes, my, yes, my lord.
Page
My lord, page 103.
103.
103. 103 is, my lord, the general provisions. Clause 3, my lord. Clause 3 is a sub-clause A.
103.
Yes, my lord, 103. 103 page number, my lord.
103 is separate. Look at, if I just- are you holding the same book?
No, my lord, it is little separate. ये नहीं है क्या?
এখন দিয়াচোন তেখেতক চাবলৈ সন্তোষ চাবলৈ দিয়া এখন চাবলৈ দিয়া তুমি এখন একেলগে চাবলৈ দিয়া নাই এখন please compare with this one if it is the same book.
Same book और है क्या?
Mr. Bui, just have a look at the course book. Is it the same book?
My lord, this is not same book. Arunachal Pradesh Panchayat Raj Manual 2002 का, ये 2018 का है.
আমার নাই নাকি এখন কিতাপ তেখেতৰ we'll have this tomorrow or day after tomorrow then.
Tomorrow,
tomorrow you're there?
Tomorrow I'm coming. Day after, my lord, it will be difficult.
Tomorrow then we'll try to bring another book for the court.
Okay.
Same.
Tomorrow, my lord.
Tomorrow?
Yes, yes.
Do you have a extra book of this?
There is one book he has given me. I don't know.
No, there should not be any.
But Lord, I think copies are there.
It should be consistent.
Oh,
We'll have it
this-
tomorrow. Okay. Try to.
Tomorrow,
No, there's copies of this are available. This.
Wow. On request made by the learned counsel for the parties, list this case for admission hearing tomorrow. Yes, we'll try tomorrow.
Very well.
Oh, yes. Okay, continue.
It didn't.
Lordship, I am appearing for the respondent in this matter.
18.
Yes.
Okay, you are trying to make some mention. What
Yes,
is it?
Lordship. Lordship, the
Wait for the where is Mr. Saikia? R. Saikia?
he was feeling sick. That is why he had to let the court premise.
He was?
He was feeling unwell
Okay,
this
okay,
afternoon.
okay.
So, Lordship, if your Lordship may, what the party says, come to term that the matter may be fixed for tomorrow.
Tomorrow?
If your Lordship may, it's kind of.
28, on request made on behalf of the. We'll have day after tomorrow? Is it okay?
Yes.
On request made made on behalf of the parties, please this case day after tomorrow. Give the date, please. Yes, we have seen Mr. Biswas after a long time. Which matter? You have come to see proceedings or for some matters. Which one? Next. Lordship, in this case, the Union of India as well as the state was directed. This cannot be your case. This is not an arbitration matter. Mr. Das, can writ petitions be done by Mr. Biswas? He is only interested to do arbitration matters.
Oh, yes, it's correct.
So it cannot be his case.
No, he can't. I can't.
There is a legal bar.
He's always into arbitration.
Yes, what is this? Lordship, in this case, what has happened is we have been compelled to approach this court because the state commission is not functioning. And in consumer, yes. We were dealing with, yes, Mr. Jammu. Research done. Still finding, yes, what? You take help from your colleague, senior colleague, Mr. Biswas. What is the now? Case law. Case law, the judgment is there, which has been passed by this apex court. This is the judgment. Even there are Madras High Court division bench. Which one? Apex court? This was the judgment by which the guidelines were framed, Your Lordship. The item, number one, which I have flagged, Your Lordship. Here, the guidelines, how to go about the appointments of the presiding officer. No, that is okay. The presiding officer is not there. What is the remedy? You cannot be left remediless. That is the case of Mr. Jammu. What is the law, case law regarding when the forum is not available? What do you do? What is your case? My case is I have filed an appeal. It is lying undisposed. It is lying undisposed of. And in the meantime, they have filed a Bakijai proceeding, which is also not permissible under the Consumer Act. There is a stay order in your favor. Yes, there is a stay order. And the Union of India and the state government is yet to file any affidavit, though the private respondent has filed an affidavit. No, we can dispose of your matter. We can say that the stay order will remain till they constitute. That can be done, Your Lordship. Why unnecessarily? Because see, you cannot leave him remediless. Neither we can adjudicate this matter here. Matter on merits. He is only on a procedural aspect. That the appellate forum is not there. I have already filed the appeal out there. It is pending. I have annexed. How soon are you appointing making the appellate forum functional?
May I, Your Lordship,
Yes.
I'm appearing for 2 and 4, Your Lordship.
Yes.
Your Lordship, we were supposed to bring on some recourse, Your Lordship. According to a last order,
Yes.
we were supposed to file.
What are your
some
instructions?
Instructions, Your Lordship.
What
We
is
have
the
received it,
instruction?
Your Lordship.
No, what is the
Justice
instruction?
H.N. Sharma retired. After Honorable Justice H.N. Sharma retired in 22, no one is.
Stating
No, what
that,
is
Your
the
Lordship,
instruction? How soon are you making it functional?
we have initiated the appointment proceedings, Your Lordship.
We can close these proceedings, this High Court case. The moment it is functional, the stay order gets vacated. Appeal is already there before the. Appeal is there. He will be given liberty to file IA for stay order. That is also there. We have filed the stay IA. But do not take any coercive measure. That is the only relief. As of now, I am seeking you. Where is there any order you're relying upon? 17 on the first order, interim order was granted. No. Order of the Supreme Court or any other court. Nothing I have not brought because I was waiting for the orders. There are judgments. Because on the last occasion instruction, they said that they're going to. Both the cases are similar. I'm not in the other case, Your Lordship. I don't know why it was tagged. You are in Ghosh Brothers. Yes, Your Lordship. And the other one, Tayo Enterprise? I'm totally unaware of who is the counsel. In Tayo Enterprise? Gautam Fukan? Who is Gautam Fukan? Why it was tagged also, I'm quite in the dark. Your Lordship. Who is G. Fukan? Oh, he's also on a similar footing. He had also approached the National Commission.
Yes.
National Commission said that it is not technically permissible to entertain because there is no order
So
from
they
the
have,
state commission. No coercive action. Okay. We dispose this two repetitions in that line, okay? Both these repetitions have been filed with a similar grievance. Full stop. The grievance is with regard to, please have your seats. Non-consideration of the statutory appeal filed by the petitioners under the Consumer Protection Act 2019, primarily due to the absence of the state, what do you call state commission? What is the expression? State Consumer Redressal Commission. Full stop. Para. It is the case of the petitioners in these cases that certain complaint was filed by the private respondent under the provisions of the Consumer Protection Act 2019 before the concerned district consumer redressal commission, in which orders were passed in favor of the complainant, public consumer. The said orders are the subject matter of appeal preferred by the petitioners before the state commission. Full stop. However, due to the retirement of the earlier president of the state commission, the appeal has not been able to be taken up. Full stop. At the same time, Makize proceeding and other coercive action has been initiated against the petitioner herein, and having no other alternative, the present petition, the present petition under, having no other alternative, the extraordinary jurisdiction conferred to this court under Article 226 of the Constitution of India was invoked. Full stop. In both these writ petitions, there are interim orders in favor of the petitioners not to take any coercive action. Full stop. I have heard Sri A. Biswas, learned counsel for the petitioner in WPC 326 of 2023. I have also heard Ms. P. Sangita, learned state counsel. And you are for?
Lordship, J. Sir, for private respondent.
And Sri so for the respondent number? 3 in his case. In my case.
Lordship, in item 19.
Other one, private respondent has appeared.
No, Lordship.
Though the learned counsel for the petitioner and the private respondent in the connected WPC 123 AP of 2024 are absent, since an analogous issue is involved, the writ petitions are taken up for consideration together and are being disposed of by this common order. Para, as already narrated above, the remedy is a limited one, which relates to non-functioning of the state commission due to lack of the presiding officer. Full stop. Para, Miss Sangeeta, the London State Council has, however, submitted that steps are being taken for appointment of the president and the members. And in this regard, she has placed on record a recent communication dated 16/5/2025 addressed, issued by the State Commission wherein the government letter regarding such appointment has been referred, and also that the department has initiated the process of appointment of the president of the State Commission. Full stop. Para? A litigant cannot be left remediless if he is aggrieved by any orders passed by the district commission, and such remedy is a statutory one, which is provided under section 41 of the Consumer Protection Act 2019. Full stop. The inability to have the grievances redressed by the State Commission is only on account of non-availability of the president of the, don't say president, non-availability of the presiding officer of the State Commission, inasmuch as the earlier presiding officer had retired on attaining the age of superannuation. Full stop. Thereafter, it is an admitted fact that no presiding officer has been appointed. Full stop. Under such circumstances, the petitioners in the instant cases cannot be left in a situation wherein they are not even able to raise their grievance against the respective orders of the district forum. Full stop. It is a different matter altogether as to whether the grounds of appeal are accepted by the State Commission. Full stop. However, it is of significant importance that the petitioners should be able to be in a position so that the grounds which have been taken to challenge the respective orders of the district forum are considered by the appropriate appellate authority. Full stop. Para? Anything to say?
No, Lordship.
In view of the aforesaid discussion, this court is of the opinion that interest of justice should be served if a direction of the following nature is passed. Full stop. It is accordingly directed that till the State Consumer Redressal Commission, Arunachal Pradesh, is made functional by appointment of the presiding officer and the members, no coercive action is to be taken against the petitioner in the respective cases. In fact, there are interim orders passed in both these writ petitions, which are made absolute by the present order. Full stop. it is also clarified that such interim, that the present protection would be operative till such constitution of the state commission. And once the commission starts functioning and the appeal preferred by the respective petitioners are taken into consideration, the interim order would cease, CES, to have its force, full stop. The petitioners are, it is clarified that the petitioners, while pressing their respective appeals, would also be at liberty to pray for necessary interim orders, which, if done, would be considered by the state, commission in accordance with law. Both the petitions accordingly stands. Highly obliged. Take this, Mr. Biswas. Right one line. Copy of the communication dated 16/5/2025 placed on record, placed before this court by the learned state council is made part of the record. Please make copies. You written this. We just need photocopies. Write one more line. It is also clarified that no merits, no opinion has been expressed by this court on the inter se merits of the dispute. Twenty-one, yes?
Yes, my lord. I have taken steps upon the private respondents, my lord. Respondent 4 and 5, my lord. So Dusty, my lord. As per the order of this honorable court dated.
You have filed affidavit?
Yes, my lord.
Where is your affidavit? They have appeared.
They have not appeared, my lord. I have taken steps on 1/2/2025 and on.
Okay. Heard Sri B. Picha, learned counsel for the petitioner. Also heard Ms. P. Pangu, learned state counsel. Para? The learned counsel for the petitioner has submitted that pursuant to the order of this court dated 21/2025, he has served the private respondent numbers 4 and 5 by way of Dusty.
Yes, sir.
And in support thereof, he has filed an affidavit on 23/4/2025. Very state affidavit, with which the acknowledgement of receipt of notice by the aforesaid respondent numbers 4 and 5 have been enclosed. Para? Upon perusal of the same, service upon the aforesaid respondent numbers 4 and 5 is held to be complete.
Wow.
List this case for admission hearing
After 2 weeks.
after 2 weeks.
Respondent number
The
5.
government, the state respondents, don't say government, the state respondents may file.
They filed, my lord.
They have filed already? Okay, don't write, huh? What is their stand? Madam, what is your stand? You are smiling? You have not read the affidavit.
I've read your lordship.
You have read? When? Everybody is smiling. That means you have not read. Okay, you read when the matter comes up next.
Well,
List after 2 weeks.
well.
Bless your lordship.
Wait, an order passed by the Deputy Commissioner, my lord, in appeal under the Land Settlement Act 2000 is under challenge on the ground that that's totally without jurisdiction.
On the ground?
On the ground that the order passed was totally without jurisdiction. But
Without
Yes,
challenging
without
the jurisdiction?
Yes.
Okay, what do you say, Mr. Ratan?
My lord, I also feel that it was beyond you.
And what do you say?
My lord, I'm respondent, private respondent.
Jurisdiction issue, you'll not have much of a say.
In the course title, in the pleading, there is no such challenging point of
Jurisdiction.
legality. Yes.
But we have
So
additional
as of now,
affidavit, I have
the
brought this
government
on
side affidavit yet to be filed.
But he has taken up the point by way of additional affidavit.
It's a low point, man.
Point of law, it can take up anytime.
Additional affidavit.
Have you been served with a copy?
That copy I have not received as of now. Earlier,
I
last occasion,
furnished to his senior, Mr. Son.
yes, my senior was received, but that copy is not available with me.
Okay, you you take instructions on that, okay?
Yes.
There is an interim order.
Yes, man.
Okay.
No, that interim order already vacated. There, many
He's not
occasions,
ready for hearing any-
many occasions, the petitioner did not ask for continuation of the interim order.
Last occasion, it was not extended. Why didn't you pray for extension, Mr. Panging? You
My
were-
lord, I have been newly engaged in this case, maybe some. There has been
But you
some-
should, you know that there is an interim order.
Yes, my lord, yes. My lord is a technical, my lord.
The order is
My lord may extend it.
No, on 9/4, it was extended.
My lord.
Only when it came up on the last occasion, 16/5, it has not been extended. We'll extend it.
My lord.
Okay. Yes, when can you be ready?
Pardon?
Will you be
I'll furnish you a
arguing
copy.
for the respondent or senior?
Senior will available. Senior will appear in this case. And moreover, this interim order passed ex parte. And for this matter, we have already filed a caveat, but it was not informed to the caveator.
Oh, why?
Yes.
My lord,
You filed a-
I did
Hearing
not-
of the private respondent,
I did
this
not
order
appear,
was
my-
passed.
This
He's raising is after
item
such a
number-
long time,
What
man.
is this item number? 20? Your Torum, Tito room.
Yes, Tito room.
Mr. Torum, you file an IA, will vacate the interim order. If you are making a serious averment statement that in spite of caveats,
Yes.
it was not served, we'll vacate the interim order. Why it is not served, caveator? What is the office note? When did you file the caveat?
I will check the record, but I was not there, man.
No, we are not attributing any fault on you. Office has to verify if there's a caveat, what is the purpose of 148 here?
The copy has already been served. Let the matter be heard by the day after tomorrow. Jurisdiction issue, man.
When did you file the caveat?
Yeah, caveat we have filed.
Okay. This was notice was issued on 2nd of April 2024. Matter discussed so many times thereafter. They are raising it now, my lord.
Yes, there was a caveat on 15/3. The matter was taken up on 2/4.
Yes, 2/4. 2/4, my lord, more than a year back, my lord. In any case, my lord, the matter says the matter is ready. Like, can it be heard day after tomorrow, my lord? Jurisdiction issue. Everything can be traced out.
What was the subject matter of the caveat?
The order, the present petitioner challenging the order passed by land secretary.
Same
That order,
order.
yeah, that order is in favor of the private respondent. Basically, this case, the LPC cancelled by the land secretary is only basis of the interim protection order passed by the GMFC court in connection with the domestic violence. So here the property in respect is protected by the GMFC court in case domestic violence case between the parties. Despite of protection order passed by the GMFC court, the deputy commissioner issued LPC to the petitioner.
Issue, my lord, is whether the land possession certificates are issued under Land Settlement Act or not.
Okay, well, yes, tell us when next Tuesday for final disposal. Okay? Heard Sri D. Panging, learned counsel for the petitioner. The issue of jurisdiction of the concerned authorities who had passed the impugned order.
Secretary Language.
Also heard Sri N. Ratan, learned AAG, AP. Full stop. Sri T. Tarun is present for the private respondent. Para, as agreed to by the learned counsel for the parties.
Manoj, can it do instead of next Tuesday, can it be after 2 weeks, Manoj?
Give a date then.
9th?
List this case for
9th
admission hearing
Election.
on
10th.
11th, my lord. 9th, I have a case at Guwahati.
11th of when?
11th.
11th.
Okay.
11th of June. Yes, next.
But I will be protected by not the interim events.
Interim order passed early to continue till the next date of listing.
Problem.
Twenty-three years.
Lordship, I am appearing for the respondent number 7, Your Lordship.
Yes.
Your Lordship, I'm on behalf of Mr. G. Tarak, standing counsel for the respondent number 156. Your Lordship, Mr. G. Tarak has gone to this native place to attend his brother's funeral, Your Lordship. So,
Okay.
madam,
Mr. Sekia, what do you say?
Lordship, there is no objection from our side. Your Lordship, only thing
Okay,
is
we'll have it some other day, okay?
the
Heard
pleadings are
Sri T.
complete, Your
Tagore,
Lordship.
learned counsel for the petitioner. Also heard Miss P. Mema, learned counsel, who appears action of Sri G. Tarak, standing counsel, RWD, and has prayed for some accommodation on his behalf. Para, Sri, you are also PJ Sekia.
I am KJ Sekia, Lordship. Yes, Your Lordship.
Also
For
our Sri KJ
R7.
Sekia, learned counsel who has appeared online on behalf of the respondent number 7. Para, considering the prayer made by Ms. Mema, the learned counsel, matter is adjourned by a week. We fix a date, Mr. Sekia, tell us the date. List on.
Lordship, if possible in the month of June, Your Lordship, on 6th, Your Lordship.
11th of June. 11 June.
Obliged, Your Lordship. Lordship,
Yeah.
only thing is, Lordship, the pleadings here is complete, Your Lordship. So it may be listed in the admission column, Your Lordship, on the next date.
It is for admission only, isn't it? Order.
No, Your Lordship, it's for orders.
Grievance for, it may be listed for admission, okay.
Deeply obliged.
Mr. Abha, which matter? Next.
It's a condemnation, my lord.
I for donation of delay, my lord. So delay is of 1,896 days.
Only?
What has happened, my lord? The set of lawyers she had engaged, my lord. She is a widow of, my lord, around 60 years, my lord. My lord, the set of lawyers.
What is the main cause of action? What are you challenging?
Challenging the eviction by the deputy commissioner, my lord.
A delay in what? Writ petition?
Wait, petition.
Yes.
Delay?
This is an IA for my lord, condonation of delay.
Delay
for
for
restoration.
for restoration?
Yes, my lord.
It was
Restoration of
dismissed for default.
dismiss for default.
Okay. What do you say?
In 2 count, my lord, it's very difficult. Either it's a contempt or a condemnation delay. If your lordship satisfied with the ground, my lord, and I'm told that she's a cancer patient, my lord, petitioner, my lord. Yes.
That she had been suffering from cancer. She has been suffering from
What is
cancer.
the main cause of action? Eviction.
Eviction.
In 1,000 days, you have already been evicted.
Part of the
1,000 days
Yes,
considered
it's
how
a-
many?
it's
How
a-
many years?
1,800 something. That means, my lord.
No, not to you, to him. The question is to him.
almost 2 years.
2 years. How many days are there in 1 year?
360.
Are you sure? 365 and 1/4. 1/4. That is important. Yes.
Yes, my lord.
How many years delay? Third, three. S.R. Rabha, learned counsel for the applicant who has filed this application under Section 5 of the Limitation Act. Oh, not 1,000 days, 1,896 days.
Yes, my lord, that's what I said. 1,800.
We thought 1,000 days. 896 is also a substantial period.
Yes, my lord. That is true, my lord.
I think you'll have to pay cost.
She's a widow, my lord, suffering from cancer. Still, she's undergoing treatment in Bibura Cancer Hospital and in.
Where is it stated?
Yes, my lord.
Where are your grounds?
Four, my lord.
No, that your ailment is not the problem. This is a problem where the writ petition was already instituted. It got dismissed for default.
Yes, my lord.
When did it get dismissed for default?
Yes, my lord. Page 22, my lord.
Which date? Which date?
38/2019.
2019.
My lord.
Where was your counsel?
My lord.
Who was your counsel?
Set of counsels, my lord. Page 20.
No.
Yes.
Okay.
Page 20.
Okay. Oh, yes. For condonation of delay of 1896 days in filing the connected miscase for restoration of the original writ petition WPC 369 AP of 2017. Full stop. The writ petition was instituted against an order of eviction in which an interim order was also passed. Full stop. However, it is submitted that due to serious ailment of the petitioner, she was not in a position to have contact with the concerned council, and accordingly, when this matter was taken up for consideration on 30/8/2019, this court, after noticing that on earlier 3 occasions also there were no representation, had dismissed the writ petition for non-prosecution. Para? Sri Rabha, the learned counsel for the applicant, has drawn the attention of this court to the averments made in paragraphs 3, 5, and 6, including the annexures pertaining to the treatment, medical treatment of the applicant. Full stop. He has submitted that the applicant was not aware of the order of dismissal and because of her ailment could not take stock of the case, and in the result the delay had occasioned. Full stop. Para. Sri R.H. Nabam, the learned AG, has submitted that the delay is of 1896 days, which is inordinate. Full stop. However, he submits in all fairness that the petitioner applicant, an aged lady who is said to be suffering from serious ailment, and therefore he would not have serious objections to the present application. Full stop. Para. An application praying for condonation of delay is to be considered in a pragmatic and justice-oriented, with a pragmatic and justice-oriented approach. Full stop. In the instant case, however, the delay is huge of 1896 days. Full stop. To examine the cause of such delay, this court has looked into the concerned pleadings and also the documents enclosed pertaining to the treatment of the applicant who appears to be suffering from serious ailment. Para. This court has also taken into consideration the cause of action involved in the connected writ petition, which pertains to eviction. Full stop. Considering the above and taking a lenient view, the delay of 1896 days in filing the restoration is condoned. Full stop. I accordingly stands allowed. Then you take up the miscase 1 of 2025. Heard the same, huh? The delay in filing the restoration petition wide IA number 36 of 2025 has been allowed today by a separate order. Full stop. Para. Since also perused the reason cited for leading to the dismissal of the writ petition on default. Para. Considering the above, this court is of the opinion that the subject matter involved in the writ petition would require restoration of the same in the interest of justice. Full stop. The writ petition accordingly stands restored to file. Full stop. List the since the petition is of the year 2019, list the same for hearing on
June, my lord. June.
Date 23rd June. Is it okay? Monday? 23rd, just check. Mr. Mao? 23rd June. Tell us. 24 Tuesday. It's 24th June.
24th June.
Disposed of. 24th June. Okay, Mr. Navam? I can dispose of. Year for whom?
I'm getting on behalf of Mr. M. Carter.
Deputy AGI.
Yes, Your Honor.
Yes, ma'am.
Deputy AGI.
Yes. Yes.
You write his name, huh? So appear on behalf of M. Katu.
25.
Your Lordship may kindly grant us 3 weeks time, Your Lordship. We have received extra copies today itself, Your Lordship.
Response number 6.
We have served the extra copies today.
No, what about 6?
6.
Respondent number 6. Who is respondent? 6 is not a state respondent.
Respondent number 6 is PWD Highways. Into 7.
Six is executive engineer, PWD highways. Pasigat. Who can take notice? You can take notice.
Highway, Mr. Rintu sir, Rintu Sekia sir was.
There's a colleague of Mr. Sakya who has just made a mention. Who was there in the court? Rintu Sakya's associate in the court? Otherwise, he can take notice, isn't it? He's the standing counsel.
Yes,
Highways.
Lordship, he is.
Okay, then why is this steps for service of notice of response is not yet taken? Okay. Though there is an office note dated 19/5/2025 regarding steps to be taken for the response number 6, the learned counsel for the parties have informed that Sri R. Sakya is the standing counsel. Full stop. You have filed affidavit, madam?
We'll need 3 weeks time, Your Lordship. We have received extra copies
Okay.
today only.
On the prayer of Ms. Sangeeta, the learned state counsel, 3 weeks time is granted to file affidavit in opposition. Let the name of Sri R. Sakya be reflected in the cause title as, not cause title, cause list as learned counsel for the response number 6. Let an extra copy of the repetition be served upon him by Sri, your name?
Ipayang.
Ipayang, learned counsel for the petition.
Obliged.
26.
My lord, as per the last order, we have filed our affidavit in opposition. And it may be posted for 10th of June. The conducting counsel.
Union of India is the petitioner.
For condonation of delay, we have objected to that. They filed the IA. Mr. Kato.
No, arbitration.
Yes, my
appeal. 37.
My lord.
Okay, yes. Would you like to file anything?
Your Lordship, Mr. M. Khatun has left the court premises, Your
No,
Lordship.
that we know.
Yes, Your Lordship.
He have filed an application for condonation.
Yes,
which
Lordship. Yeah.
He has objected to. Will you like to file any additional, any rejoinder?
Rejoinder. Your Lordship, it's better, we would like to take instruction. Yes, Your Lordship. I haven't been instructed any.
Heard Sri so-and-so learned counsel appearing on instruction of Sri M. Kato, learned deputy SGI. Also heard Sri H.K. Jammu, learned counsel for the respondents who submits that objection to the IA praying for condonation of delay has been filed. Para? On the prayer of so-and-so, this side. Matter is adjourned by 2 weeks.
My lord, can we fix date? Conducting counsel is Mr. Adhar from Guwahati. 10th of June?
Adhar.
Ramsudhar.
Okay. On the prayer of so-and-so, matter is adjourned by 2 weeks to enable him to seek instructions. Para? As requested, list on, yes, tell us.
10th of June.
10th of June is okay?
Yes, Lordship.
10th of June.
Highly obliged, man.
Wait, my lord, though the IA has been filed for stay of an advertisement that is 7, my lord, the pleadings are ready, my lord, we're fixed for admission hearing. There's some urgency in the matter, my lord. Can it be taken up tomorrow, my lord?
Tomorrow, not possible. Tomorrow we have had many matters.
My lord, day after.
Next Thursday.
My lord, the selection is on 25th, my lord. There was no interim order as far as item number 27 is concerned. 28, there is an interim order, my lord, similar matters.
25th is when? Sunday?
Yes.
We'll have it in the next week. Oh, next week.
My lord, it's not a very big matter, my lord. My lord has already dealt with similar matter here, my lord, in this.
What is the matter?
My lord, cancellation of selection process. Only on the ground ratio was not maintained. There was advertisement for around all the districts. Ultimately, that was allowed all others. All were installed initially. And this one, my lord, these 2 districts, they were cancelled. As far as 27 is concerned, only on the ground that the ratio was.
What do you say?
My lord, that is ratio of 1:3, but that was not mentioned. On that ground, my
Only
lord,
ground.
it was.
There's a direct judgment of our High Court. And
How many did you, what ratio did you follow?
My lord,
1:3 comes, 7 posts, my lord, 21 comes. What they did was they called everybody who obtained more than 60. 35 persons were called for the interview.
Then what is your grievance?
On
the
that
basis-
ground, the selection process was cancelled.
My lord,
We
on the
were
basis of
selected,
this,
my lord.
since there is a violation of the ratio, my lord, that selection process.
But you had given, you had called more candidates.
My lord,
More candidates.
they called more candidate, my lord.
All
35
above
candidate.
60, my lord.
Instead of
Nobody
calling,
was deprived, man.
instead of calling 21 candidates, 1:2 ratio, my lord, 1:3, my lord, they have called 35, my lord. On this ground, my lord,
That is only.
The purpose of having a ratio is to give the maximum
Yes.
my lord,
opportunity.
that's,
If there was infraction of the ratio by calling less number of candidates,
Yes, yes.
a case would have been made out
My lord.
because you are not giving adequate opportunity. Now, more candidates have been given opportunity. Why should you cancel it?
my lord, that was the only, my lord,
There is only.
since there's a likelihood of public outcry, there's a sanction,
That
my
is
lord.
the-
That's the reason, my lord, that's why this is.
There were, in fact, selection process was conducted for all the districts. All were installed. Ultimately, my lord, everyone selection completed in respect of the others.
This can be disposed of.
Yes,
My
my lord,
lord.
now itself, my lord, if
Now?
you. Since, my lord, the exam is, in the other matter, might have gotten
We-
stay, my lord.
We
In
just
item 28.
intentionally said, we
Right.
knew that this reaction would come for you.
Can it be, my lord, tomorrow, my lord?
Tomorrow, many matters are fixed.
Day after, my lord. I have my lord's judgment also.
Huh?
I will take 10 minutes max, my lord,
Okay, tomorrow we'll try.
tomorrow.
Tomorrow, Mr. Pagan.
My lord.
My lord, they did come in the admission column, my lord. I will not press the I, my lord. Admission.
You're taking a chance.
Yes.
Orders may be on the. No, you make a mention, we'll have it. Paucity of time would not permit the matter to be taken up today, Kara, as requested by Sri Panging, by citing our list again tomorrow. Sri Tagum, Learned Standing Council, Health,
Yes, yes.
and Ms. Sangeeta, Learned State Council are present. Okay,
Obliged.
rest.
I will take 10
Mr.
minutes.
Das, which matter?
Nothing.
31, my lord, 31. No, I just, I know well, it's very difficult. Handling so
You
many
take-
cases.
Take,
So many cases.
We'll give a case,
No,
date
I-
of your convenience.
No, I'll just.
Mr. Dolari, which matter?
Same method, but it is counted 4 hours time. No, tomorrow, what I.
4 hours.
4 hours.
No, no, my lord, you will argue for
Minimum.
I need more than 1 hour.
No, I'll not.
State will also.
My lord,
decide. So,
he'll, 1 second. He'll argue 1 hour. I'll also argue 1 hour, not beyond that. Your lordship can see the watch and I will finish it off. Just 2 minutes if your lordship give me, without opening of the file. Why this matter is of very urgent. My lord, 2018, I'll
You
just.
tell us, we'll give you a date.
No, tomorrow, my lord, if possible.
Tomorrow is not possible.
No, I'll just.
Tomorrow, 4 hours, it's.
No, I'll just not 4 hours. I'll just tell my 5 minutes, my lord. If your lordship finds that there is no urgency, then your lordship
No,
will present.
we are not doubting your,
No, but, just
your prayer that
My lord-
is urgent, but tomorrow
my
is
lord,
not practically possible.
your lordship just here for 5 minutes, my lord. Just here for 5 minutes, then your lordship will
And
take a
pa-
call.
And Mr. Pangi has already left
My
after
lord-
fixing his matter.
My lord, only
We
5
cannot
minutes.
recall the order also.
Only for 5 minutes, my lord. Only 5 minutes I am requesting your lordship to just, without opening of the brief, 5 minutes, my lord. Within 5 minutes, I'll just, your lordship finds that there is no urgency in this case.
But tomorrow it will not be
2000, my
possible.
lord, will
Tomorrow and
kindly-
day after tomorrow
No,
not possible.
2018 a notification has been issued, 2018. And the land has already been taken by the state. Already it has been 2018. There was litigation 2018, urgency under 41. It was taken by the government. 41 on the request which is made by the army. 2017, there were 3 notifications. Ultimately, my lord, my possession was taken over by a notice under 21. 21, the possession handed over. I am not in
This is
possession.
under the 13 Act.
Yes, 2013 Act. 40, under 40. Now, there was this litigation before this honorable court. All these letters were sent to the army. Then army has processed and sent it to the government of India. At that relevant time, notification issued by the state and the possession was taken over. Once the possession was taken over, they calculated 125 crores is due to us. It's my lord, the villagers where it is represented through a power of attorney holder. Now, through a power.
Okay.
Now, there was a writ petition which was filed before this honorable court in somewhere in 2018. Once, my lord, I did not get the amount.
So we came up before this court. There is an order passed by this honorable court that within a period of 3 months, it should be paid because it is a case under 41. 41, urgency clause is there. So then the court said, we want to see the records because the question has been cropped up before the learned single judge that whether the position was taken over or not. Record were produced and on the perusal record, it was found that yes, the position was taken over.
Yes.
In pursuance to that, there was an order passed by this court that within a period of 3 months, the amounts would be paid. This was the order passed by single bench. This was challenged by the Union of India before a division bench.
Okay.
Now, there were two, the grounds was one, the learned single judge, this honorable court has passed the order, no doubt, not commenting on the merit of the case. But their whole contention is that there would apparently the appropriate authority is a user agency, that is Government of India. So whether that permission or whether sanction was granted or not, without sanction, whether that amount order can be passed for releasing that 122 crores. This is one. Now it's remand back. Another matter which came, another order, two parts of the order. Another part was that whether a power of attorney can be maintained or not. That for the first time before a division bench. Power of attorney can be maintained or not. Now in an article under Article 226. Now these 2 points has to be addressed. So the matter came up before this honorable court. So the honorable court.
The issue regarding power of attorney, how was it answered by the division bench?
Yes, division bench said no, division bench for the first time. Division bench said no, this has to be decided by the learned single judge regarding the power of attorney. This has not been answered, only it has to be answered before the learned single judge. Now the matter came up before the single judge, lot of time, deliberation was made and it was taken to Guwahati also, once the matter was taken up by a single bench, one of the judge, and that was taken before the Guwahati High Court bench. Principal say. Now the first question, power of attorney in respect, then we satisfied and it's a court said it is maintainable. Second issue is cropped up is regarding there is a sanction which is given. Tacit approval is there or not. The entire matter was looked into it. Then, my lord, they said, the honorable single judge said, you place the record before the court, whether there is any sanction which is granted or not. A lot of orders were passed. They were not producing it. Ultimately, an additional affidavit has been filed before the court. Now, from the additional affidavit, if your lordship looks into it, there is a sanction which has been granted by the ministry. So, if a sanction is granted by the ministry, that's every matter. Sanction has, the court has said that whether there is a sanction or not. I found that there is a sanction.
Answered.
That has been answered.
Yes,
only remains, one second,
Only
remains the power of attorney.
Yes.
Power of attorney, my lord, there are 2-3 judgments which was placed. But the learned single judge, while it was deliberated, it was sent it by division bench, it was not recorded as such in the order say regarding the power of attorney.
Okay.
It was not recorded as such. But 2-3.
The remand order has specifically mentioned to address power of attorney.
Power of attorney also.
Okay.
So 2 points, power of attorney, my lord.
But if the sanction part has already been answered in the effort.
I think that's not by.
In your favor.
Yes.
Is it required to adjudicate or answer the aspect of power of attorney?
No, I think your lordship, this is my.
Mr. Vadolo, what is
My submission is 180 degree opposite to Mr. Das submission. There is no sanction from MOD, my lord. And land is not in our possession. That we are having a 3.5 acres of land possession. Earlier it was in possession and the land had been paid. Land had been paid. Now the land is given back to the my lord landlords. That is not in our possession. Even lordship, we can produce the tomorrow. Yesterday's the satellite copies also. Only 3.5 acres land is in our possession and rent has been paid for. So this is the thing. So whatever Mr. Tas is saying, I'm 180 degree opposite to that. There is no sanction from MOD volume, Ministry of Defense.
But more than that, if you are not in possession, where is the question of compensation?
So there is no question of compensation. That is not sanction.
Is dispute on fact?
Yes, absolutely. Absolutely dispute of fact.
No, there is no question.
So that is why actually, I know Mr. Das will address for nearly 2 hours. So let's let the matter come in the some
No,
of
no,
the
there is no
some of
question.
the time.
How can
it
he,
is-
my
no,
learned friend case said I'll address 2 hours?
No, no.
On what
maybe
ground?
1 hour, maybe
No,
1
how
hour.
can you
Okay,
say 1,
okay,
2 hours?
Okay, so
Don't
my
say 2
submission
hours
is that,
address.
okay,
My lord, I will address
So let
only.
it come on Monday.
No, no, let
Then
it.
one of the Mondays, then Monday, Tuesday, or Wednesday, that can be continued.
No, no, my
So
lord.
it-
No, but,
Because this is only feasible.
but Mr. Das, if Mr. Doro is seriously disputing on facts, we do not know. He may be correct, you may be
No,
correct.
no, my lord, I'm saying.
But are we in
no,
a
no, no,
position as a writ court?
There cannot be any dispute in respect of possession. One, because in section 21 of the Lara Act, they have noticed government whereby possession was taken over. So taken over, that the handing and taken over also has been done. My learned friend, the state has already taken over the possession. My learned friend can't say because it is by way of notification possession has been taken. Can he deny now possession has not been taken over? Number 2, 605, 2 minutes I'll just say, of the affidavit which is filed by Government of India. When the court said you produce the record on one, kindly see several orders have been passed. Now in page 605, all this bunch went to the ministry. Now there are board proceedings were there. In the board proceeding, whatever the records were there, which was said and which was analyzed by the state along with the Government of India, defense as state officer sent it to for a board proceeding. 2017 was a notification. 2018-17, there was deliberation made by the Government of India. They spelled out about the 41 and said, yes, it has to be acquired. They are saying, without our consent, how a notification has been issued
Now,
by...
who is in possession of the land?
No, we are not in position. The state government, they have taken our land.
Yes.
No, my lord, 1 minute. They said, my lord will kindly see, my learned friend said 180 degree, I'll be again 180 degree. This one line, in the interest of the organization, the sanction of Ministry of Defense is granted to occur. What is 180 degree? This is 180 degree.
No,
This
I
is
put
your,
the document.
this
There
is your,
No sanction.
this is
no,
your.
This is 360 degree.
No sanction, no sanction, my lord.
This is
we
same
never-
side.
No. apart from
Ultimately
that, my
comes to
lord,
the same side.
This is
we never asked.
But he is reading some. What is this then?
Then what is this?
That will examine, my lord. Lordship will examine.
See,
Because
No,
what
this is
happened-
a, what paper is
This
this?
is
I don't know, my lord. We have not issued that kind of letter. We don't, I don't know.
What is
No, what is this document?
It's an additional affidavit by the Government of India. What is saying?
Yes. That-
Please
that-
do not
that
say
satisfies your
something.
lordship. That will-
Part of the additional affidavit?
Yes, it is
will
part of
satisfy
the.
your lordship.
What is
How can you
Because
disown
the
this?
sumoto,
see, my lord.
what happened, my lord, sumoto, this government of owners of bodies, they have issued the notice. Under section 11, subsequently that was withdrawn.
That is a wrong submission.
Yes, my lord, that will produce the report.
Until there is.
That will, that's why
Okay,
we said this matter will
okay.
take 2 hours, at least two
Okay,
hours.
next Wednesday.
No, let it be next Wednesday. No. Tomorrow I will just come.
Tomorrow.
We will try, my lord. I'll
No,
go by VC. I'll try, my lord, if possible.
On
Please, my lord,
next Tuesday.
because, my lord, if it
No,
is
not
not
tomorrow. Tomorrow and day after. Do not please.
on
do not-
Friday, let it be on Friday.
Friday.
Is a request is being made, my lord, tomorrow.
Right.
It is not possible, my lord. This is the whole.
Next month, my lord.
Next Monday.
One of the Monday.
Next
One of the
Monday.
Mondays will pick.
Next Monday by
Yes.
VC.
Yes.
Next Monday.
Let it come on the Mondays, then we'll pick Monday, Tuesday, Wednesday, whatever.
We can continue.
We
Okay.
can, we can got it.
Third Sri D Das.
My lord,
Learned Senior Counsel.
He will engage some other lawyer. It will not be possible, I think.
No, no, you be.
No, my-
You address on VC.
It will not be possible in my all the time.
Read us, Learned Senior Counsel, assisted by Sri S.R. Rabha for the petitioner. Also heard Sri Y. Doloi. The Learned
For Union of.
the Learned Senior Panel Counsel for Union of India. And Sri R.H. Nabam, the Learned ASG for the state of Arunachal Pradesh. Full stop. Sri Das, the Learned Senior Counsel, has expressed urgency and has submitted that the acquisition proceedings were initiated sometime in the year 2017. Until now, the compensation is yet to be paid to the petitioners. He has also submitted that though there was an issue regarding the sanction by the Union of India,
Yes.
such sanction appears to have been done, which is apparent from the additional affidavit
Yes.
filed by the Union of India on
On this additional affidavit has filed
on
on Somewhere summer, August 2020.
In August 2024.
Which had been opposed by.
Pre Dolly, right? The learned CGC has, however, stoutly denied the aforesaid aspect of grant of sanction and has opposed the writ petition for the para. Be that as it may, comma. As paucity of time would not permit the matter to be taken up today, comma. List for admission hearing on.
No, let it be after 2 weeks then, my lord, because it will be very difficult.
June 9, 10.
So let it be any
on
of the
16
month. As per convenience to the
16
senior
June.
local.
16 June, my lord, it is.
Monday.
Yes, one of the Mondays, then you can finish it. Monday, Tuesday, Wednesday, whatever is required.
16 June.
16 June.
Oh. I am already, my lord, from Guwahati. Already they are saying that you are settled in Arunachal Pradesh or what? They have already stated that you are already in Arunachal, you are settled or what? No.
So let it be on 16, my lord, yes.
16th?
My lord, let it be any other date, not 16.
You tell us.
We will, my learned friend is there, he will mention it.
Well, mentioning is a problem because we are not from Guwahati, so they will be fixed. Any date, my lord, convenient, any date in the month of June.
Mr. Das, we'll do one thing. We'll fix a date. If there is a problem on either of the side, you can inform the other side that
Yes.
we'll seek an accommodation
Yes.
and fix a particular date.
Yes.
Okay. 16th we tentatively fix.
Yes.
Okay.
Advocate General is also saying that 16, my lord.
16th. 16th. Okay.
For me, my lord, I don't have any. Only the outside you have to accommodate yourself.
A lot of days I am here, my lord, that is why. I thought that I'll finish it on the matter
We'll
and I'll
think
go
of
back.
deputing Mr. Nabam to principal seat.
No, this matter has traveled to single bench. Number of times the matter was taken up by this court. Number of times.
Principal.
Not once. Yes, it was taken
Only
from here to the principal seat, my lord.
And on 16,
Number
that will be
of-
disposed of. 16, 17, yes.
16th.
No.
Yes, 16th. Rest of the matter dates will be given by the court master, unless it is urgent. Otherwise, yes.
There is an interim that may be continue, your lordship.
Wherever there is an interim, please
And,
inform the court master. It will be
Can
extended
it be
till the
fixed on
next day.
4th of June?
4th of June, huh?
4th of June,
4th of June, interim extended, huh?
obliged.
Okay.